from 2011, madam. To this spot? Yes, madam. This is the order of the GI order passed in favor of the respondents. Thereafter, they file FO. FO is dismissed on the ground of which court? My Lord Justice Didas. Okay. Thereafter also they file it is also delay. It was argument. So one matter. Yes, don't worry. You get a process. I will not list. This didn't happen, but they did. Specifically, adjourned to 23rd 10 minutes that are not been listed. That's why I am. That is fixed in the lower court matter. We'll see just how. What is this? This is discussing about convenience matter. Convenience order. Nothing is going to happen. Because he specifically adjourned to 2. We'll see therefore what can happen. Yes. What is this matter is about, sir?
But it has not been specifically date has been paid. But
you give the we'll see, check it up. Pardon me. Yes, this is clearance application. Stay was granted, not a blanket stay, it was stated that if an adjournment, if the application is filed, the later will adjourn for 8 weeks. I told you that it will come seriously. The right impact matter, it is directed as an intent that if an application is made to the lower court, it will adjourn for 8 weeks. But 8 weeks is expiring today. That is the type of stay that was granted by the Honorable. So, right, we'll see. I just will be trained and give a government servant, give a central government servant. That is why this order was passed. We'll see. And was specifically urgent to 23 so we define yes. I don't want to every matter there will be some urgency or the other. If you start entertaining like this, then in every matter, you have to give preference. Then I don't want to give preference to any matter because everything should come seriously so that nobody will have any grievance. That's the idea. Yes, madam. If pressing urgency is there, then one can think of. We'll see. What about the pardon? Yes, item 123. Matter has been considered with parties 2 o'clock. I'll pick it up. Item 4 is offense, by the way. Matter has been settled. What is the offense? Wait. Oh, the lady is there at 12 o'clock.
Item 56 may be permitted to next week, my lord. Item 56, my lord.
Fresh matter. Okay.
My lord, item 58, my lord. My lord, item 58, and Mr. S.P. Das, may be taken over next week, my lord.
Next week, I am not sure. It will go to December. I am not
my lord,
sure.
Item 6, a senior advocate Kepti Paumik has died on 2021. So, party has taken the file.
6, huh? 6. There is replacement in the family. Who is? Yes.
item 52, my lord. How to withdraw?
52.
Has been acquitted.
Acquitted. 52 withdraw. Yes.
I didn't want to mention minutes. There is item 82. The matter has become infractuous. Pray for withdrawal.
52.
Thank you.
Item 62, my lord.
Sorry?
Item 62.
Yes.
I pray, my lord, let it come 1 week after because some documents are needed in that basis.
Okay. Urgent.
Item 130 minutes. May I take reference 130 minutes.
130.
This is a case your lordship wanted me to produce the reports and we got the reports. Find the reports, my lunch is ready. This kind of disposal, after lunch I have some after some Arvind some matters, some of the courts. It's just Mr. Lords.
You just tell him so that we let him come.
So what I suggest, Lord, let it come, let it be parted out for the day. Tomorrow it will take up. The weekly this morning, it will be available.
Okay, no problem.
Pass it.
I'll not to look. We'll
pass it tomorrow. And same each item 31 notes.
131.
131. This is a case for staging operating notes. And in this case, my learned senior Mr. Roy has submitted a written note of submission and also documents on
it is there. And he's there.
What I suggest, let it come tomorrow, but it's possible.
My lords, may I humbly submit, my lords? On the last occasion, my lordship categorically stated the matter will be taken up at 2 o'clock. But unfortunately, there has been no noting. Let it come on Wednesday, my lords. I will take 5 minutes and conclude it.
Okay, Wednesday.
Agree.
At 2 o'clock, my lord, you would see that it is direct. That
Wednesday, 2 o'clock.
I'm doing it.
10 o'clock, 1 o'clock, 2 o'clock,
Okay,
2.
2 o'clock. Wednesday.
Ma-
Mhm.
On 6th. Wednesday is 6th, my lords.
Wednesday, I think. Okay.
Total 5 minutes. I will-
Obliged.
Okay.
Obliged.
Okay.
Item 89, your lordship. In that matter, my senior Mr. S.K. Das and his associates had filed a wakalatnama, but his name has not come on record. It has been filed in 2020. And also, as per the last order, we have also prepared
What do you want?
let his name become on be there in the records, and also the matter kindly be taken up on some other date, because he's
Matter, man.
your lordship, actually my senior is attending a medical emergency for that reason.
Medical emergency. Give a short date, huh?
Item 89.
Give a short date.
Obliged.
Okay. Any other mentioning? Online mentioning? No. 107 weekly. Yes. 51. Yes. Let us start from 51. Yes. What is this matter, sir?
No, this is. It's not.
Nobody there. Pass over. Okay.
53.
Fifty-three. What is this matter?
It's a modification of order method, but ID is not there. As per notice method, they copy note for disposal of case.
Pass over. Oh, this was it. Yes.
54.
Yes. What is this matter?
Recall of witness method.
Hmm?
Recall of witness was examined, cross-examined in the year 2018, my lord. Thereafter, my lord, only to encourage this process, my lord, yes, filed a petition under section 311, share petition, my lord. It's the conflict not there, my lord.
Okay. Pass it over. Okay.
55.
Again, pass over. What is happening today? Nobody is interested to do. 56.
56.
I think they are scared of the new team.
Not the I think they have not seen the voting.
What is the note?
Voting is already 51. From 51 also will take note.
I don't see.
No, this is easy.
I had the interaction with my lord friends to join recently. And in fact, they're much more aware. You also can see it.
No, that's what I said. The other side is scared of the new team.
Agreed.
Nobody is coming today.
Maybe generation one step ahead.
Yes.
57.
Pass over.
My lord, I'm here.
Yes.
This is an application for 82 for crashing of the cognizance taken against the present petitioner.
1 minute. What is happening? Hard copy sheet.
The present petitioner has been only implicated.
1 minute, sir.
Yes, madam.
There is some software issue, server issue. Yes. Yes, sir.
The present petitioner, I will draw your kind attention to page 30, running page 30 of the charge sheet, madam.
Okay.
It is clearly mentioned that I interrogated with the accused persons on Falana, who have said that they have committed the dacoity along with the present petitioner and others. That is the only statement, and basing on which the present petitioner has been shown as an abscond. My humble submission, case as against the person who has confessed the guilt. As against them, the case has undergone acquittal.
Warrant has been issued against you.
That has been acquittal. The other acquitted persons who have made the confession or who have implicated the present petitioner, that case has been entered in acquittal.
Where is that
That
judgment?
is Annexure 5, my lord,
5.
at page 50.
Okay. Read the relevant part.
Page 50. No, I'll be reading 53.
Okay.
Right.
No, it's so short a judgment, 3 pages judgment, acquitted.
Yeah, acquitted, my lord. That's just,
Only 3 page judgment.
yeah, 1, 2, 3, 4. Yeah, 5 pages, my lord. And where the above noted discussion reasoning, I'm bound to
Come to page 53.
53. Yes, my lord.
53.
That's what I'm reading.
Yes.
Para number
On
7.
scrutiny. On scrutiny of entire evidence adduced on behalf of the prosecution, it transpires that none of the prosecution witnesses, including the informant,
Yeah.
has stated in his evidence that the accused persons had looted
Looked at the cash and mobile phone from him, and any of the prosecution went on the alleged date.
Yeah, what do you say?
Well, here he is absconded and they remain outside. The case of 395.
Let's see, but how, you see, this is the quality of evidence you have insofar as the co-accused persons are concerned. Even if he is put to trial, what will you get? It will be wastage of court's time, everybody's time.
On the same time, my lord, sometimes the persons who are not outside the my lord court, the witnesses are coming and telling against him, my lord. They are merely because they have not committed the crime. That does not mean that this person has not committed.
That's right. Theoretically, you are correct. Theoretically, you are correct. But practically propose
For that reason, my lord,
the same witnesses will go and say the same thing.
None of the witnesses have identified this. He was not named. It's only the
and he has not, my lord, given the deposition copy.
Even
He has mentioned that yes, these persons are not the accused persons. Somebody else is there. If he has stated that somebody else is there, then there is probably possibility of this petitioner is an accused, my lord.
the entire prosecution.
So let him solve the copy of the deposition, my lord. So if that can be solved the.
So what we can do is what you are on bail.
No, my lord.
So I will allow you to appear and target the trial within 3 months.
I do not.
Because there is nothing.
At least.
Let it be over.
My lord.
Okay, madam.
Ah.
I may be allowed to surrender and be surrendered on bail. So that-
And you face the trial. There is nothing. The trial will. That's the better idea. I'll write,
Direction may kindly be given to release him on bail. madam.
I'll write this.
Yes, madam. Thank you.
You give it to me. Yes. Time is it.
Obliged.
That's a good idea.
Yes, madam.
Because both the things, both the sides will be. Yes. I'll make it 3 months or what? 3 months.
As your lordship pleases, because if the witness, eyewitness will come, that the person with the informant will come, and he has not stated that this person is not.
Then I will be good. Okay, 3 months. Yes. But Mr. Naidu, I'll have to put some cost. You have to give it to bar association. You have been absconding.
He is a permanent resident of Tuba.
Therefore, you pay more. And that's too, Mr. Murthy is appearing, then it is obviously.
As your lordship directs.
You give it to bar association.
Yes, madam.
Okay. Yes.
I am pleasure losses. Yes. Whereas here is a case, plus the wife has filed a case under section 376 against the husband, and cognizance is taken. That is the case. Your lordship, for the moment, I would like to place plus the marriage notary declaration.
You bring your wife. You should, this wife, 376. Where is your, where can you, where from I get that you are the wife?
Yes.
Okay.
That's 6.
Why did you open number 2?
In this case, affidavit and declaration from that application follows the
Who is this notary public?
declaration that is,
I have issued notice to the notary public also.
marriage, who will share the truth and the witnesses are also here.
What kind of marriage is this? Going to the notary public and give a declaration that I am married.
It is not marriage certificate, not all, their notice, notary.
I simply issue notice because in any case they must be there in relationship or something of that sort.
Yes.
I'll issue notice.
Yes.
But this is not a marriage.
There is not a marriage and
That's the reason.
kindly see the dates.
Like the reason 376 years, because people there, they're not, they're simple. Simply issue notice, let us see. Let us see, letter comes, we'll see. Okay. Let's issue notice, yes. That there is a notice, I have tried. Yes, I will make you. But next week or next week, you will also since you are also in notice, so it will better to come both individually. Otherwise, they should go also notice. Yes. Then let's till then next week. That I'm telling next week. All right. Yes.
60.
60. Okay. 60. Password. Password. Yes.
61.
61 minutes, that's all.
Okay, password. Yes.
63.
60.
Nice mover actually.
Yes.
Petitioner is a nephew of the informant. Dispute arising of family dispute.
1 million. There is some problem device are not opening. Yes. Hard copy secretary rafta. Right. Huh? Oh, wait. Let you open. We'll tell you when it is. By the time it opens, yes.
Petitioner is a nephew of the informant.
You are the informant.
I am the petitioner, my lord.
Yes.
Petitioner.
No, you are the accused.
For my lord. 482, passing of covenants, my lord. Compromise has already been done. Only notice is.
So what is the offense?
307 other offenses are. The compromise is only in the question of this petitioner only. The young boy.
No, but that's right. But if there are many accused, just see how many accused are there. Eight accused. The injured or complainant cannot choose one of them and say that I will settle with him. Either full settlement or
No, here in the 161 statement.
that is not merit. That's not merit. Merit I will examine differently. But once you say that the matter is settled, it is the 307. 8 accused persons are there. The complainant doesn't have that right to pick one of them and say that I'll settle with him and not with the other.
But this petitioner is concerned, no one connected with the.
No, merit you then forget about the settlement part. You satisfy on merit.
I am satisfied.
Yes. What is your name? Your name is Sanjeev.
I am satisfied.
Yes.
I am satisfied.
Once I issue notice, then you will satisfy. That means you are not satisfied.
I am satisfied. I am satisfied.
I'll simply issue notice, huh? Yes, issue notice.
I is there. I is there.
I notice, yes. Remove application.
I is there.
Is there any chance of settlement qua the other accused person or not? You tell me.
Yes, chance. There is a chance.
Oh, 100%?
Yeah, there is a chance for settlement of other person also.
You settle with other accused persons. Process fee you file by tomorrow. I'm thinking of staying is because once I will not say, then things will be aggravated, then this chance of settlement is
Chance of settlement is there.
right. Mostly for the proceeding till next date of hearing. It is made clear that no adjournment shall be granted on the next date of hearing. Okay, after 3 weeks. And meanwhile, you persuade other people. So the settlement, if possible, yes.
Item 64, my lord, quashing of the affair
Yes.
on the ground of compromise. And at the meantime, my lord, subsequent development that the informant and this present petitioners.
What is the offense, sir?
Offense was, my lord, that annex of 1, I have filed, my lord, 341, 294, 376.
One minute, sir. That the party is about being settled issue. So therefore, we pray for stay of further proceedings regarding the statement made in the past. Yes. Yes.
My lord, offense was, my lord, under section 341, 294, 376, 506, 32VA and 32VA of SC and ST Act, my lord. And here, my lord, that both the informant and the present petition married, and the informant has filed an affidavit before the oath.
You take out notice and do.
My lord, already appeared. Informant, my lord.
Where?
That, my lord, her affidavit is there, my lord.
In this court,
My lord, slips.
appear.
Yes, my lord.
Where?
And one of my friend is appearing, G Singh. This is the receipt, my lord, of affidavit.
In the proceeding, nothing is reflecting.
Nothing, slip is there, my lord.
Appear before whom? Which court?
Before this honorable court in this application, my lord. That is the slip, my lord. Already filed.
So you might have filed. Where are they? Call them.
You personally, my lord. Piece of a date, my lord. I will intimate her, and then both of them will. Yes, my lord.
You call them when? Tomorrow? After?
Then, my lord, next any date, my lord.
First Monday, Tuesday, though.
My lord.
Do them.
Yes,
I'll watch. Yes.
With their identity cards.
Yes. Monday.
Again.
Huh? Bring them. Okay.
Monday, my lord.
Yes, Monday. Tuesday. Tuesday. Okay. Tuesday.
Coming Tuesday.
Lord, the facts of the case is that, my lord, the petitioner filed a case under section 138(1) of NI Act, my lord, in the lower court because he gave some amount to the opposite party. But check has been dishonored.
Yes.
Therefore, he has filed. But in the complaint case, my lord, the learned JMFC had dismissed my petition, stating therein that it is premature because the petition has been filed 3 days before. My lord, that annexure 1, page 9, your lordship may kindly.
Where is that?
My lord, page 9, annexure 1, my lord.
Hmm.
My lord, I am submitting, my lord. The case record without date or order already had from the side of the complainant. I was the complainant, my lord.
You file a fresh one.
Yeah.
You file a fresh petition.
Well, fresh petition, I have prayed for re-hearing of the petition, quashing this order, my lord. He has explained very well, my lord. And in the NI Act, my lord,
And earlier there was no provision of condonation of delay. Now there is a condonation of delay. Section 14.
it may be dismissed, my lord. No, it is before 3 days. 3 days.
What do you want to show?
My lord, complaint cannot be dismissed by magistrate, my lord, on the ground of premature.
Let us counsel for the in this petitioner has challenged the order dated 2/8/2024 passed by Leonard JMFC 2 Kotak three Kotak, whereby the complaint under section 138 NI Act has been dismissed, being premature. Counsel for the petitioner relying upon the judgment 5 submits submits that the magistrate had no power to dismiss a premature complaint under section 138 of NI Act. Issue notice.
Direction to re-hearing my petition, my lord.
That's right, madam. Otherwise, in the absence, I can't do it. Issue notice, let him come.
Because my that dishonored check and 1,000 fees, everything is in the court, my lord. Again, where to verify? I will find.
Yes, who is appearing? State council. What do you want to say? See, the complaint 138 complaint is dismissed being premature. She is relying upon one judgment. It says that magistrate can't dismiss prematurely. Issuing notice to complainant, accused has no meaning because the complaint itself was dismissed. So what she says is relegated to the trial court to entertain and issue notice. I'll set aside that then. Yeah.
My prayer is, my lord, let me direction be given to rehear my.
That's what I'm doing. That's what I'm doing. Relied upon so and so. Okay.
On merit. Cautions order, my lord.
I have perused the complaint and the order dated 2/8/2020. The magistrate, the learned court below has dismissed the complaint case filed by the petitioner oblique informant.
65 copy देना है. 65 copy देना.
It's all right.
Now state will particularly.
State, it is private. Yes. Being premature, as the same stated to have been filed 3 days before the statutory period of limitation prescribed under section 138 NIA. Relying upon that. I am in agreement with the contingent of the petitioner. Therefore, I'm inclined to. Therefore, the impugn order dated so and so pass by so and so in 1CC case number 4/2024 is set aside, and set aside the complaint is restored to its original file. The court below is directed to hear the petitioner on merit and proceed with the complaint case in accordance with law.
Just expect copy of the order, my lord.
Yes. Well, huh? Yes.
66.
My lords, I'm in this matter through VC, lordship.
Yes.
This is a 482 CRPC petition, NDPS matter. Lordship, the date of FIR is 17/8/2017. The charge 8/2017, lordships. And the FIR was to, charge sheet was to be filed within a period of 6 months, lordships. And the page number 34 is important. I have an trial court orders judgments. Lordship, an application was filed by the IO for extension of the time. And if we see at page number 34 of the order dated 12/2/18 and 13/2/18, it is evident that no notice was served to me, to the petitioner, or no notice was served to the lawyer. Neither the accused was present in the court, nor his lawyer was present in the court, and order was passed in his absence. There is complete violation of rule of natural justice, audio drum partum, lordships. And there is so many judgments of the Honorable Supreme Court and this Honorable High Court also. So I was to be released on bail as per this wrong order. And on the last date of hearing, Honorable Court was pleased to hear me at length, and was a direction was passed to the counsel of the estate to file the affidavit.
Yes. What is the instruction you got?
Affidavit has not been filed yet, lordships.
Yes, last order was to get the instruction, State Council. Yes, madam.
Lordship, for the period I had to be in jail for 6 months. Now, 3 to 4 years I am in jail. I was on interim bail due to.
That's right, but see, there is a complete new team on the other side.
Yes, Lord.
From today. So, they are entitled to at least one opportunity.
Yes, Lordship. Yes, Lordship. No issue. Any short date may be given.
Yes. Take instruction, read the last order of the coordinate bench, and this is a legal issue, you have to seek instruction. Okay. On the request of the legal counsel of the state, these the matter after a week or so. Okay.
Any date may be, Lordship. Any date.
Yes. Specific date will be given.
I'm obliged, Lordship. I'm deeply obliged.
Yes.
67. May I please, my lordship, I am in DC, my lord.
Yes.
Lordship, this is an application challenging the rejection of order that is 13th of June 2024, wherein my application filed on section 311 of CRPC stood rejected by the learned court below, lordship. Lordship, this is proceeding under section 138 of the NIA, lordship. Kindly have a glance to page number 11, annexure 2, my lord.
Yes.
That is the
examination of the complainant on the very date he was also cross-examined, but no particular important questions were asked to the complainant. Kindly have a glance to page 11 and 12.
Come to your application and 3 and 11. Why have you not asked?
Yes, sir. My application is just page 21.
The same day, some questions will go to complainant. What are the questions?
Lordship, question is that only 3 to 4 questions are asked. So, no, sir, my
In the application, you have not formulated the questions.
Lordship, kindly have a glance to page 22, paragraph 5, my lord.
22, yes.
Yes, paragraph 5, my lord. That
Yes.
those none of the material questions were put to the
That's right. What are the material question I am asking?
material questions with relating to the cause of action.
You don't tell me where have you written it?
No, I have not written the questionnaire, Lordship, in my application.
Material means you can keep on cross-examining him 100 times. How does it make difference? You show me in your 482 petition. Have you mentioned those questions?
No, my lord, I have not mentioned because
How come the trial court rightly rejected it?
no, Lordship is absolutely right. I go down, Lordship.
And you got full opportunity to cross-examine.
No,
Just
my
see.
lord. Kindly see, Lordship. That is why I prayed before this honorable court to look into the page.
When the matter is fixed in trial court, before trial court?
Probably it was posted in the last Wednesday. Probably the next date is has not been intimated to me, Lordship. Probably in this week it has been posted for accused.
No, probably. You must tell me. I have to issue notice to the complainant.
Yes,
There can't be an ex parte order like this.
No, notice may be issued. Lordship.
Issue notice. Next week.
Yes, Lordship. Next week, Lordship. I humble submit if the matter is posted in this week, I may be permitted to file an application for adjournment or may be allowed.
In the event the matter is taken up in the international, the petitioner is at liberty to move application before the court for seeking adjournment. Yeah. The process fee, okay, by tomorrow. If the process fee is not filed by tomorrow, the stay order, the concession will be withdrawn. Okay.
Day after tomorrow, Lordship. Only one day after tomorrow.
Day after tomorrow. Okay. Yes.
My lord, 68, question of the cognizant view of a compromise, my lord. The petitioner and informed have filed a joint affidavit, my lord. They are present, my lord. As per your lord's instruction, my lord, they are. All the petitioner and informed are present, my lord. What are the allegations? Offense under the 341, 324, 294, 325, 506. What are the allegations? Allegation is that when the son of the informant was going for marriage procession, my lord, the accused person made some comment for which there is a dispute, my lord. That is the way.
All are present. First, where is the complainant?
Yes, ma'am.
Chandramani Malik.
I am for the other side. The complainant.
The name sounds like a lady. You have not asked now. Okay. Just asking. Chandramani. What are the injuries and simple injury? Facts.
Because they are also board last Monday. Two persons are present there. That case is attended to all the petitions are also present.
Settle होइला केस काहे फाइल करथिलो
अरे बोरो नेथिलु पिला मते अपन काहे कि हेगला
केते पैसा देली माने
सर पैसा हम निजो गांव का साम पैसा कोन देबो हमर पिला
you give it to Barney. No. 10 of you are there. If you do like this, you must be burdened. You should feel the pinch of it. How much will you pay? To the bar. You will pay something. You have to have the pinch of, you drink and assault people. How much you?
No, I am the complainant.
You the complainant, you will have to pay it.
This person should get me from that order. And then if I will pay to the party, then I will suffer again.
The instance of opposite party number 2, FIR number 4 came to register. And the investigation is complete. Investigation of the case has been complete. And where is the charge order?
Charge annexure 2, my lord.
After the complete and charge sheet has already been filed. Pursuant to the trial court has trial court by the order dated 2/9/2022 have taken cognizance of offences under section 18 of Matrimonial. Okay. So space and full stop accordingly. Charges have been framed. Cognizance have been taken. Yes. So when the matter showed that the parties have settled their dispute, they filed the joint affidavit. Yes. Yes. Joint affidavit dispute. All the accused persons are present in the court today in person, represented by their counsel and identified by him. And they have also filed the self-registered copies of their Aadhaar card to establish their identity. The complainant is also present in the court in person and also represented by his counsel, who has filed the self-registered copy of Aadhaar card to establish their identity. From the query from the court, the complainant says that the petitioners are their co-villagers, and due to misunderstanding, he had filed the case. However, due to the intervention of the well-wishers and the village entry, they have settled the dispute. Petitioners, all the petitioners have you seen your affidavit? All the petitioners have signed. Affidavit. Joint. Have you seen your affidavit? It's not a 5 and opposite not 2, my lord. No, just see. What kind of affidavit? I don't understand. Just see, you come to the joint affidavit. Joint affidavit. First paragraph, read. That the petitioners prefer this application for questioning so and so. Opposite party number 2. You write joint affidavit filed by the petitioner number 5 and opposite party number 2. What about the other people?
Authorized to swear this affidavit for the formality.
You will file affidavit for all of them, or you don't file. Out of 10 accused, only one accused will file affidavit.
Applicable, I have looking after this case on behalf of the other petitioners, lots of paragraph 3 and daily authorized by the other petitioner.
What is the authorization? What is the authorization? It is suit, representative suit. Authorization. And you will authorize someone to kill someone. What kind of pleading is here? This is very pathetic pleading. These are very minimum things. Rest of them file the affidavit.
Yes, I will file.
I'm crossing it, but subject to file. 5 of them should file affidavit.
Yes,
they should feel the pinch of it.
Yes,
judicial process. The police has investigated, they have wasted time, and judicial time is occupied because of these people. They should have some.
I will like to post update, my lord.
They should file separate post update. Okay. Right on. The petitioner number 5 and opposite party number 2 have filed joint affidavit inter alia stating agenda. For 2 to 7. 2 to 7 of the September. Counsel of the petitioner submits that insofar as the other accused persons are concerned, although they have not filed the affidavit, however, they undertake to file the separate affidavit before this court during the course of court. the day. According to immediate legacy petition, there the petitioners are first paragraph to do, petitioners are accused in so and so. They can find an instance of so and so, next for the immediate legacy petition is found. Okay. Who represents put?
Madam.
Yes, Madam, then transfer the state leader. Submits that since the allegations are keeping in view the nature of allegations and the fact that the parties have settled their dispute and they appear before court and reiterate the same, there is no legal impediment in questioning the case. Against the petitioners. Regarding to the submission letter to the party and the fact that the parties have settled their dispute, subjecting the petitioner to trial would be a futile exercise. In the facts of the present case, the judge is squarely covered by the judgment of the Honorable Supreme Court in Gyanti, Mother of India, and PSOC. Therefore, the petition deserves merit. Accordingly, the so is cost subject to the petitioners paying 1,000 each. Give 1,000 each to the bar association, 5,000 to him and 5,000 to bar. Subject to the petitioner depositing 1,000 each. 1,000 each out of the said costs for 10,000 to be deposited by all the petitioner. 5,000 rupees, 5,000 will be shall be deposited with the bar council, bar association, and remaining 5,000 shall be paid to the informant injured. Yes, cost. Every file, yes, and 10,000, 5,000 is deposited in the bar association, 5,000 giving. Yes.
69.
Yes, sir.
This is the second of litigation method. The open order is the annexed of 5 matter running page 46 matter.
Sorry?
Running page 46, open order is.
Yes.
Earlier petition has come to this honorable court and the honorable court directed that is annexed of 4 running page 43 matter,
yes.
operating person.
Yes.
43. And counsel for the petitioner submitted the perusal of medical examination report and the victim indicates that the injury are simple in nature. Therefore, even if the allegation made by the informant is taken into
Yes, the medical report, no case and the criminal is made out because the petitioners have neither used any weapon nor any intention to kill the victim. Certain fist blow given by the petitioners. Yes, that's what.
And then the operating person is 46.
Yes.
46 on perusal of FI.
Yes.
But on perusal of the way, it is revealed that present accused petition, namely Basant Kumar Jain, his son Mohanka Jain, and Shahar Jain are with the informant and his elder brother in obscene word and assaulted, and the other informant fell down due to assault. The accused petition in informant sustained pain on our throat and knee. When the outsider intervened, the present accused petitioners returned to
Yes. What is wrong in it?
Well, that is operating last person 47 matters. 47 matters.
Yes.
The intention and the knowledge was not true.
How will you elucidate intention from the charge sheet? You have no intention. You might not have used the weapon and all. That's right. But if you have attacked with the intention to kill someone, it was an attack.
In a sudden manner, there is a tussle regarding parking of vehicle. That is the parking rule. And in the though it was the evening time, but there is many people in the locality manner. There is no preparation. 007 only
for intention you need not have preparation. There and then also you can think of, out of rage also you can attack someone with intention to kill.
You have to sort of a fist blow and only fist blow. 307 is not acted. Therefore,
How will you get intention part? Intention is very, why will you check it? Ask him this has, out of heat of rage, he might have done it. And
regarding parking of vehicle, there is a person. Yes, other neighbors and
Madam, because his intention is to kill. That is reflected in the rejection order. The document is not there. But he has pressed the neck, that is also there. He is complained that there is a neck. So there is intention to kill, my lord. So once the intention comes, my lord, no injury is not.
That's right. Injury is not parametry.
So 307 rightly the learning system is rejected.
Assistance.
The trial court is correct there. Practically whatever, but as per the law, the trial court is correct because at this stage the court can't go have a roving inquiry and decide whether intention was there, intention was not there, all these things. If you can settle, I can just issue notice. Have you included informant?
Yes, already included.
Give an opportunity if they can settle. I'll just simply issue notice. I am not doing anything. Issue notice to opposite party number 2. So accept notice for sale. Okay.
No,
no. I am not inclined to cross. Only thing is you bring him, you can persuade, then something can happen. This is not a case for interference at all. The trial court order is absolutely correct. You can't find a single mistake at all. I'm not inclined, in fact. Because if you call him, something may happen, so that's the reason. He must be known to you. He must be known, the informant must be known to you.
Yes, known to you.
Maybe only. So therefore, may, agree to something other.
Parking of the vehicle.
That's right, I understand. You give it the fact value and issuing notice. Otherwise, the impure order is absolutely correct. You file the process, let us see after 1 week. Yes.
70.
Yes. Password.
71.
Video.
Next time.
Next group. Password. 72.
72.
Yes.
Make it, Lords.
Yes, sir.
Your Lordship, the present petitioners earlier approached before this Hon'Ble Court, Your Lordship, and that has been withdrawn and filed a better application. So this is the present petitioners before Your Lordship.
What is that?
Your Lordship, that is Your Lordship, the earlier CLMC 4892/2023. Order dated 17/9/2024.
Okay, you want question of the entire
proceeding, Your Lordship. And matter is already settled.
Opposite party number 2, Your Lordship.
Settled between both the parties, Your Lordship, and the present
Your Lordship.
Yes.
Please.
Yes, the counter case is already in court.
That is.
Annex
Dated 26th June 2023, Your Lordship. CRLMC number?
That is, Your Lordship, kindly come to page 19, Your Lordship, the order portion.
19, huh?
Yes, Your Lordship.
19.
Page 19. 19. Yes. That is CLMC number 2138 of 2023. Order dated 26/2023, Your Lordship. Married.
Was your cost? This is the cost. Where are the parties?
So this is the first time coming before your
last time party will not come.
Will come tomorrow, Your Lordship.
No, you bring them today itself. What is this, crossing petitions, cross case has already been crossed. You should have brought them. Tomorrow. There.
Yes.
Bring them. Yes. Kind of them. What is the offense, by the way, in this case?
That is 376 to end and POCSO at least there is 6 and 17.
What is the age of 72 now? What is
17 plus.
Huh?
17 plus.
What is the age of this man?
That is
20 years.
Yes,
What about this Sanjay Parikh? Who is he?
He is the father of the
accused.
accused.
What is the allegation against him?
Sorry?
What is the allegation against him?
Allegation on the 316.
They were in love with each other, your lordship.
No,
That's
what
what-
is
Right, yes.
the role of this, his father?
Father help करथिला तांको.
What is the terms of settlement now they are saying to?
After appearing majority, से major ହେଲା ପରେ से बाहागर होई करी. Yes, your lordship.
That, to that effect, you have filed an affidavit.
Yes, your lordship.
Okay.
They have to.
Where is the affidavit?
No, file will file.
He's
That affidavit will.
okay, you bring the affidavit. We'll see.
May not.
73.
That's 73.
Advance copy of affidavit, you give it to the other side, they will verify it.
Yes,
Yes.
I know.
No copy has been solved. 73.
73. Yes, sir.
No copy. 73 item.
73. No, sir. Nobody guess. Copy is not being supplied, huh? Let him come, we'll see. Yes. Pass over.
74.
Your Lordship. Yes. It's an application, my lord. The petitioner has been implicated as an accused on the basis of affair, lost by the informant in the matter of a trust. A trust was constituted by the petitioner, the informant, and some other persons, and the purpose of the trust was to form some educational institutions, right? And it is alleged that the president, the secretary, the petitioner was the secretary of the trust, and the petitioner was the president. Informant, my lord, the president. After some days, after 2 days, there was a dispute between two persons, my lord, president and secretary, as usually happens everywhere, my lord, for the monetary transactions or something like that.
Yes.
The president lodged the affair, my lord, against the secretary, saying that there was some misappropriations and some resolutions were fabricated, manipulated, my lord. So, my lord, that resolution book was seized by the IO during investigation, because that is the crux of the matter, my lord, because the allegation aspect will be revealed from the resolution book. The resolution book during investigation was seized by the IO, my lord, it was not produced. During the familiar charge, I filed an application under section 91 saying that a resolution book which was produced has deliberately withheld by the IO, my lord, with a mischievous intention, let that be produced. That was not produced, my lord. I filed an application under section 91 that was also dismissed. The view of the Supreme Court as well as the other high courts, my lord, a document which is relevant for the purpose of trial cannot be withheld by the IO.
Obvious document.
Yes. Sterling document.
And you are agreed by that order.
My lord,
You are agreed by that order of rejection.
I am aware. Acknowledgement. Yes.
Yes. Let us come to that order.
Your Lordship, kindly see.
What does it say?
The order is annexure 3, my lord.
Yes.
Page 35. Annexure 3, page 35.
Hmm.
And the relevant portions, my lord, is as page 38.
38, yes.
On perusal, the first line, on perusal of the case records, it appears that the IO during investigation seized different documents on the different seizure list. On perusal of the case records, it appears that on 29/11, during the evening, the IO seized the resolution register of Hon'Ble Charitable Education Trust containing 90 pages up to 90 pages. But the said resolution register was not submitted in connection with the in connection with section 91 of the CRBC, less than the provisions of the summons to produce the documents of other things, and the entire 91 he has analyzed 91 and said 91 is not applicable, but the document if it is a
Can he say that all the documents were seized? That's what he says.
still were not produced. Not produced. I am argued by the order. It's not produced. I filed an application under section 91. It is a finding I am pointing out. The finding it was seized. It was not produced. Still, my application is rejected, my lord. And the affair allegation is, my lord, I have manipulated the mediation list. That is the most crux. That is the most relevant documents for the purpose of deciding this case.
So this is in whose position these documents are there?
I have seized either from the president or secretary, but the document is a kind of secret pertaining to the affair. The affair allegation is my lord.
Well, show me the seizure list.
Pardon?
Show me the seizure list.
Seizure list, my lord. They should
Show me the seizure list where this document is seized.
Then the finding of the sessions court is cannot be.
I need to see the seizure list. Unless I see the seizure list, how will I get it? The finding may be wrong. I can't, many times you people attack, the finding is wrong. So document has to be seized.
No, the sessions.
You find the seizure list. Let me see whether this document is really seized by the because the order which you read, I am not able to follow. He says somewhere he says 90 pages, somewhere he says 19 pages. What is that?
You will also may kindly see Annex 2 at page 20.
Yes.
Serial number 10.
Yeah.
Which has been given.
Serial number 10.
Yeah, yes, item number 1 of the my lord. On dated 29/11/2019 at 1:10 p.m., the SD Malik seized the SI Malik seized the following documents on production of the complainant Sachidananda Chaudhary.
One register of mass on education contain 90 pages.
Yes.
Use up to 19 pages.
Yes.
Xerox trust copy dated so.
Thereafter, my name for the resolution.
So this must be all part of it.
No, that is my point. It's a part of the investigation, my lord, but that was not probably how
What is it? Mr. Vishal, just see, in the seizure list, if you have seized some document, it should be form part of the charge sheet.
But it should be placed on by the time of the trial.
The problem is the police comes and sees everything.
Yes, madam.
And the document which may give some impetus to their defense, those documents are withheld.
Yes, sir. Exactly that is.
And selective documents are filed. The document, see, there is a concept of obvious document. If there are obvious documents, the obvious documents withheld and file the charge sheet. If you have not seized, I can understand. You have seized it.
Now, you have filed the application under section 91.
Because you're not
why he is trying to say 91, why he has filed it. He says that these are the documents, the resolution and everything is seized by the police, but the charge sheet is not filed. So therefore 91 is rightly filed. Who knows, on that basis he may be discharged also. No findings could have been taken out.
I know the discharge application. We have filed the section 91 petition. Now, when page 38,
You should only answer me whether this document was seized by you or not. If you have seized, you have to file it. It is obligated on your part. If there is no judgment, I will write a judgment. This is what is this practice. You seize all the documents. You sit in your office, select the documents which are the good documents which support them, you throw them out. Then why have you seized them?
let me take instruction with it.
You tell me whether you have seized these documents or not.
Yes, I will take instruction.
Yes. If you
have shown the document that he has used.
No, that is no, I don't know. You are making this allegation. Maybe with the along with the charge sheet, everything is filed.
Yes.
You know, you lost where is the charge sheet then? You lost only the charge sheet you have filed. Where is the document?
You lost my direct to produce.
In the document, it's everything.
I have shown the list of documents prepared by you along with the charge sheet that it was seized. That's my answer.
Seized is all right. Whether it was supplied to you or not. No.
It will be written in the rejection order.
Rejection order, don't go away. Rejection order you are challenging. That's wrong order. Therefore,
yes, on perusal of the case records, it appears that on 29/11/2018, I was seized the resolution list.
That's right. The charge sheet. Yes, madam. Legal counsel, Mr. Naik, counsel, senior counsel, submits that his client had moved an application under section
91 CRPC for production of certain documents which were seized during the investigation and form part of the charge sheet. However, the same documents were not filed or supplied to him. And he has taken me to the description of the properties seized during the investigation, which indicates that on 29/11/2019 at 1:10 p.m. The investigating the SI DD Malik seized one register of Ma Bhandaragarani Educational and Charitable Trust containing 90 pages, out of which 19 pages were used. 19 pages were used. And this same document, though seized, was not form part of the charge sheet. Therefore, he moved an application under section 91 of CRPC, which has been rejected by the impeachment. Issue notice, Mr. Bishwal, counsel for the state accept notice. Notice he should seek instruction as to whether the documents which were seized during the investigation were form part of the charge sheet or not. Charge sheet or not. Yes.
Stay my road because your lordship.
And only charge has been framed now.
Yes.
The petitioner accused may move an application before the trial court seeking an adjournment owing to the fact that the matter is sub-judicial for this court. Yes.
Some cases of full stay should be continued. Your lordship's usual order is if you file an application.
I am not averse to file giving full stay, but the problem is, you see, there are stay orders operating since 2015 and 16. Nothing is happening. You are senior counsel. You are briefing counsel.
Your lordship will also be equal expert. Your lordship also is this side. Once the stay is granted.
So therefore, partly I am giving so that balance is maintained. At least in this process, your briefing counsel will file the process fee and regulates. In many cases, you will see 2016 convenience order. This is going on. And what is happening is we are asking for data from the trial court. Why the cases are pending? They say that you have stayed. You have stayed with the therefore not able to proceed. That's the reality, ground reality. Therefore, yes. I'll be requisites. And after 3 weeks,
yes,
fixed it. Okay. I'll just come. I'll just.
Right. So,
120. 28.
23.
123.
Re-application arises out of matrimonial dispute that has been settled. Both the husband and wife is present. The first application, the petition of the mother-in-law, and in the second application,
How many cases are there?
three cases, LRC. 4567 by 2023, in respect of mother-in-law, LRC.
Yes. What is the terms of settlement?
Minors.
Terms of settlement.
Settlement, LRC, divorce already, expected divorce allowed in the court below. Now the criminal proceeding will be technically 370 by 511, my lord. 511 is there. Here, what happened?
Due to political dispute, my father-in-law, subsequently, my lord. Really, both of them were present, my lord.
376.
511. 511 is there, my lord. 511 is 376, 511.
Charge sheet has been filed.
Yes, my lord.
What are the allegations?
Allegation charge sheet also filed under 376, 511.
What she has said?
Allegation, my lord, she stated that she went to the paddy field and she asked the petitioner, where is her brother-in-law? And the petitioner said that I will help you. And thereafter, allegation, my lord.
Where is it? 164 statement?
164. 164 not
recorded?
164.
164 statement recorded or not?
Victim herself was the FIR.
And where is their?
That is not at page 10, my lord.
Page
10, my lord.
10. Yes. Read the allegation. Read the allegation.
निवेदन व अभिप्राय है कि जन्म उर्मिला जेना स्वामी Lord, I am reading the relevant portion, Lord. ମୁଁ ଆଜି ଦିନ 3:30 ସମୟରେ ମୋ ଘରକୁ ସାଇକେଲରେ ଯାଉଥିଲି ଓ ମୋ ଦେବରକୁ କହିଲି
Yes.
Higher 2007. 2007. Time of
294. 50634.
34. At the time of student, college hostel, ପିଲା କିଏ କୁଆଡେ ଗଲିନି ଗଣ୍ଡଗୋଳ କରିଦେଇଥିଲେ ଟିକେ ସେଟା ଫେରି ଯାଇଥିଲେ।
You should be lenient.
ଆମର ହେଇଥିଲା ଏବେ ସେ ବାହାରକୁ ଯିବା ପାଇଁ
Where are they?
ରସିଦ ବୋର୍ଡ
Where are they? Ashwini Kumar Das.
Ashwini.
He is accused. Subrat Kumar Singh.
Yes.
What are the allegation? Exact allegation.
Exact allegation.
What has he done?
The hostel grill gate forcible at the time of election, college election. But some of the students are forcibly grill gate, hostel grill gate forcibly enter into the hostel.
What is he doing, Ashwini Kumar Das, right now? The 2007 is the fire. He is 42 years. What is he doing? Where is Ashwini Kumar Das? Accused. Come here. What are you doing for living?
कौन कौन से
Judicial जो permanent local service
permanent local.
And you are also doing all these things. You are supposed to solve problem or creating problem for what? You are permanent employee. Administration of opposite party number 2, FIR number so came to be raised against the petitioner. Allegation against the petitioner is shown. The petitioner and opposite party number 2 are present in the court in that paragraph. The FIR was registered Vivek in on 10/10/2007. What is the stage? Stage of the trial.
Stage the cognizance after cognizance the case is pending.
Cognizance order.
Cognizance order not found the this.
We are not able to find out.
Charge sheet has been. Do you have the date? Do you have the date? Cognizance. He must be knowing he is working in judicial.
Received the summon also.
Okay.
Only when he applied for passport, then only he came to know that a case is pending against him. And that too from 2007.
Okay. Let's also for the petition submits that although charge sheet has been filed in the present case, he has no knowledge as to whether cognizance has been taken in cognizance of offences has been taken by the court or not. He came to know regarding the pendency of the present case when he applied for the passport. And thereafter he contacted the informant and filed the present petition for quashing of the proceedings. Quashing of the proceedings. The informant who is present in the court has filed an affidavit dated 4/11/2024 in trail stating as under 2 and 3. the counsel's appeal for the parties submits that the incident had taken place when both the petitioner and opposite party number 2 were students, and students already settling their life, therefore, the opposite party number 2 has decided not to proceed against his fellow classmate. Hence, he joins with the petitioner, praying for quashing of the entire story. Mr. Vishal and counsel for the state submits that since the incident has taken place when the petitioner and opposing party number 2 were the students and they are settling their life. The allegations are not serious in nature. Therefore, there is no impediment, legal impediment in quashing the FIR. And the answer is so good. Take it. Yes.
77.
Yes.
May I please? This is a bench of man.
Yes.
NBW was issued on 2nd of April 2024.
NBW 24/2022. Bill? You are on bill?
3rd of November 2020.
2020. Okay. 30 years. 30 years. Was 500. Yes.
78.
The bench of matter, NBW issued 9/10/23.
9/10/23.
Madam.
And you are on bill? We have debate? No.
Bill certificate copy.
No, not certificate copy is not given. You can be debate.
Ali sir, NBW issued order
On bill लिख दिया. 500.
on bill.
500. Okay. Yes.
79.
NBW was issued against the present petition on date.
NBW on?
Issued on the present petitioner on date 5th of August 2024.
Where is the order?
Order annexed to page 18.
NBW on 29/9/23.
It was released on 27 September 2023.
20?
Released on 20 September 2023.
2023.
29, sir.
When the NBW was issued?
NBW was issued 5th of August.
5th
of August 2024.
5th August, okay. 29/9/23 bill, 5th August 24. Okay. 500.
80.
We have it also. NBW issued on 23/5/2024.
23/5?
2024.
24, okay.
Yes, ma'am.
Bill?
3/10/2023.
3/10/23, yeah. तो 30 सितंबर को नवंबर को दो, ठीक है? Okay. 500.
NBW issued on 8/2024 and bail was granted on 3/2/2021.
500. Yes. Yes.
83.
82 urgent. Withdrawal. Yes, sir.
Here, my lord, the petitioner is in custody since 2011-2023, my lord. Charge sheet has been filed on 16/3/2024. Case under section 302-123-201/34 IPC.
CD there.
CD, my lord.
Get me CD next week. Next week. The new team. Let them read. 1 week.
84.
CD is not on.
CD. Call for CD, yeah? Yes. 84.
Item 84, my lord.
CD.
And today I am for the informant, my lord. I have already filed my letter.
I didn't hold your appeals for the informant. And
record my record.
Call for CD. List met. Yes.
85.
May I please, my lord?
Yes, sir.
Section 3.
My lord, CD is not available.
My lord, 3 times.
My lord. Today is the fast food you are giving, but you have to make sure that the CD comes. My lord. Okay. My lord. The new team let them.
Yes, my lord. So did
CD. Yes.
86.
Lord, same CD is not available.
CD, yeah, 2 weeks. Yes.
87.
Lord, same 86 and 87 accused and co-accused.
86, 87 साथ लगा दिया, ठीक है? CD. 88.
Lord, same CD is not available.
CD.
Hard day.
Now benefit of doubt.
9/10/2020.
Now you have to give benefit of doubt. First one weekend. Yes.
Next week ବର୍ଷେ ପରେ ରହିଲାଣି 60 କିଲୋ ଆଉ 3ଟା ଡେଟ୍ ପଡ
60 kilo.
60 କିଲୋ 1
Get it, huh?
My lord, instruction was to get the criminal antecedent also, but neither the CD nor the criminal anything is not.
You have to pursue. Man, you have to unless pursue and he never come.
My lord.
Okay. Yes.
next week
We done the call to local police and ask them. And call the direct the call to the SP of the otherwise the IO if you call they will not send.
My lord.
Yes.
90.
18 is
CD में CD में पास होता है CD तो नहीं
80?
86 86 and 87.
86, 87 CD hasn't come. 1 week that asking for press. Therefore, short date only. Because they are new team, so therefore.
You team no, I located with all sorts.
Still, no, but they have to be acquainted with the, system. Yes. They will be given. Yes. 89. Again.
90. This is a matter of restoration of the petition. When the matter is called for, the petitioner could not appear before the court.
When was it dismissed?
Dismissed on 25 November, February 2022.
Huh?
Within time I have
20?
filed the 22. Within time I have filed the restoration petition within that time.
Do you have anything on merits?
And because the court is always liberal to restore the petition of the.
I will restore, don't worry. Main petition, do you have anything on merits?
Yes, I have on the merits.
That's not there, na?
No.
Allow and restore to its original file, list it for hearing. Allow.
90 and 91, sir.
90, 91, no, huh? Both allow, restore to its original file and list. Give me the.
92.
My lord, 92, the copy is not received.
160 case, private. Yes.
The restoration of
LMC, my lord. Restoration, yes, my lord. Once it is restored, the very old matters, list it early. Because the earlier two matters, 2011, 2012 matters. List it early. Okay. Restore. Okay. Pleasure.
93.
Restoration application was filed within time?
Yes, my lord.
Yes. 93.
93 is also for restoration.
When was it?
It is still not pointed out in.
There is
It is still not pointed.
okay. This is old matter. This is also old matter.
It's not a police officer and due to official.
No, that's right, but the matter was filed when?
Person. Yes, sir, my lord, no delay has been. Yes, sir, no delay has been.
2015 matter, huh? 2015.
My lord, 2 years delay was.
The delay is a criminal and.
No, delay in filing
Not in the
restoration.
No, my lord. In the sir, no, not a pointed out, man. Yes.
Okay, restore to original file, you list it for you. Yes.
94.
Yes. None appears, my peers. Service, opposite party. Yes. Services, pass over service. Yes.
95.
Five, the petitioner file a affidavit for withdraw the matter, liberty to file a better application.
Yes, sorry.
Li-
Withdraw.
Withdraw.
Okay. Withdraw with liberty to file
File
better.
better.
Yes. Leave it. Yes. 97. 97. Request. Additional document 5. Let's see. 97. Yes, 5. Yes. Okay. Pass over.
98.
Here now I have chosen the affair. I have very limited prayer because I have failed my attempt number to get the anticipatory bail. May place same surrender same day. And because co-accused statement is the allegation and the basis of the implication. And so far the allegation is concerned, it is alleged that in a laterite stone was attempted to be caught and removed from a government plot. That is the allegation. And in the meantime, the co-accused who has been found at this spot, he has been released on bail.
Where is that?
Not FIR.
Except FIR, there is nothing.
Page 7.
Oh, FIR I have seen, but that accused has been granted bail. Where is that order? You have not filed, except FIR, you have not filed anything. How we link, how I have to everything believe on the basis of whatever you are saying.
Then
File something. File something to at least.
No, because I know by I have failed in obtaining the anticipatory bail.
Certificate copy is not required. You know that. Certificate copy is not required. You file it so that at least I can
next week
on record something. Next week. Next week. How many accused are there in this?
Only one.
Only two criminals. The other one has already been granted. Yes. You file that order, or carry to I can.
But things even it has been also been avoided in the FIR that a person who has been arrested from he was there.
So, file it, so it should come on record.
All right.
Yes. Next week, huh? Would you take it? Yes.
99.
Yes. There is some petition notice newly added opposite party number 2. Pass over, right? Pass over.
100.
24th was declared a holiday. So we could not have filed the requisites. So it was filed on 28th. Maybe accepted. Petition. Okay, we accept. Requisite and then requisite may be used for the purpose of serving opposite party number 2 lease the matter. Yes. So 14 तारीख थिला जदी फेलोशिप थिंक किसी पापा नले अब गोटे वीक घुंचे देबे कोन ठीक कर देबो ठीक nothing.
101.
Filed an IA for dispensing with filing of certified copy minor. I have earlier filed an IA for dispensing with filing of certified copy minor. And I have already obtained the copy minor. That's all right.
But tell me one minute. What is this case?
The case minor, they actually by the annexed original fact of the case minor, they were challenging the order of proceedings passed by the 11 JMHC Bhubaneswar on dated 11/9/2023 manner. Actually, fact of the case manner, the petitioner has invested money in the organization of the opposite party number 3 and the unjust placing man.
Yes.
And in 2016, the complainant was working with the 4-man electrical at Khorda workshop of Adarsh Novel Corporation Limited, Bhubaneswar, where the opposite party number 3 was the managing director and authorized signatory of the state company. Both are given to the same meeting, that is Longevally Barambo, upon request of the opposite party number 3, he has invested with 4 lakhs in the state company with, and the opposite party number undertakes that which will return this one to ₹5,60,000, that is including the interest of 8% by
was invested by the month of 31st to 12, 2021, 2020, my lord. And I have obtained the letter, my lord, which I have filed, my lord. And there are
Paid that money. He has not got that money.
my lord, there are
Persuading to invest money with opposite party number 2
in the organization.
and he did not get it.
Now, reports to pay on the issue of change of rupees 560, which we have invested in the bank of Guarantor, and same has been begun in my head. For that reason, I find an 160 case number, 45,2021 my lord. Before the 11 Institution Guarantor my lord, and I am pending before the 11 JMHP Guarantor exam. In order to check. Three. Have issued the check of rupees 5 lakh. They have received the money 4 lakh. When the actual they are going to 5 lakh 60, including 8% as per calculation. By 31st 2020, why the combination of I am pushing back. The matter has been stored by this honorable court by the Sorum number 1578/23 the proceeding has been stored before the warrant and in between they have filed another case in the year 2022 that is the present case matter 8190/22 allegation that the economic assured investing money and misappropriated
arising out of compromise manner. Let him take out the notice. You take out the notice. Let him come. You are you ready to pay that money?
But
you have to pay that money which you have taken.
Let them
let them come. Because there are 138 cases are also pending. All the matter can be settled. Because the money release some 5 lakhs or something. Issue notice. Opposite party number 2 and 3. Returnable after 1 week.
I
will not stay. You bring them. There is not the cognizance order is not required to go.
But they have
nothing on merits. Nothing on merits. I am giving next week. You bring them. I'll try and see that all the matters are over. I'll be requisite by tomorrow. I'll be requisite by tomorrow. Reach it after 1 week.
I may pardon this moment, Lords. Item 97, Lordships.
97 you
Lordships.
pass over. Yes.
102.
The consent of the senior. We carry detail to detail fix it. Detail gas to 45 minutes. Detail gas.
Do we borrow at 2 p.m. So this appeal can be disposed.
Yes.
103.
103, I swear this matrimonial technology rules after one.
Let it be added to the hearing list because stay petition was there. I have filed my objection. So let them copy the petition copies. My learned friend may supply me 2 copies.
You supply.
Supply. It may be added after their.
Yes. I have included that in the weekly list. Let him supply and I'll take it up. Yes.
My learned friend is saying more time. So
weekly list is there. Yes.
104.
104 Lordship, they are already dismissed. They have filed High Court for stay of a conviction. Petitioner already dismissed from his service. Now the petitioner suffering the blood cancer. Lordship will maybe early hearing.
Argue now? What early hearing? What could be the earliest than just now? Argue if you can.
it is a trap case.
Trap.
Do you have anything on merits? Let me try. If you don't think, if you think that there is nothing on merit, then don't try. Let it be heard.
Let them supply the copies of deposition. 1 week after, let it apply to copy.
After 1 week, I'll take it up. Get ready with synopsis, written submission and all.
Because he is suffering from cancer, let it be taken for hearing. Let them supply the copy. I will get myself. I am also collected matter.
You prepare it, need to know 140 with all evidences and everything. Sorry, when do you want? Next week?
1 week after.
1 week after, 3 o'clock. Get ready and come.
Yes.
With the little note and all. Huh? Okay. Yes.
Apply कर दिया मतलब कि ready.
105.
Absolute injury custody, 6 months custody. Conviction, 3 years conviction. On the date of delivery. Condemnation of there were 3 accused. 2 accused have already been released on bail and fine has been
Sentence, how much? What is the sentence?
3 years, 3 years. This appeal may be tagged along with CRLA 585/2024.
Bail granted, realization of the fine amount is paid.
They delay 16 days.
Delay
116 days delay.
Reasons stated in the application, the delay is condoned, appeal admitted and all. Yes.
Maybe tagged with CRLA 550.
Yes.
Direct note.
For the opposite party, to determine whether settlement was possible, the case was referred to the mediation center. The mediation report is at flag 1. The next mediation date is on 6th of November.
Mediation process is still going on. Is the matter awaiting the mediation report?
After the mediation.
After 6th, last week of November. Okay. Last week.
107.
Yes. Let's see. So you have to unmute from your side.
Yes, my lords.
Yes. Yes.
So, since I have no instruction, my lords, it's not possible on my part to address your lordships on merit. Because at the time of filing of the case, you were suffering from cancer. I tried my best to contact, but I am unable to contact my lords. I am not able to know about his position.
Now, what is this matter is about?
But
What is ICC case number?
Yes, my lord, this is a negotiable instrument at 138. But the merit, your lordships, my lords, he paid the money and taken out the Tata Safari car. Only the check was issued because some outstanding dues were there against the loan taken for the purchase of the Tata Safari car.
Yes.
In the meantime, I do not know what is the position. So that's the reason, my lords.
I'll simply dismiss it.
My lords, as no instruction, my lords.
Yes. No instruction. Counsel for the petition service, Mishra, yeah?
Yes,
Yes.
108.
Bless, my lords.
Please, your lordship, I am on VC, my lord. I may kindly be allowed.
Yes, yes.
My lord, just before we start, I just submit, my lord, this now my concerned counsel joined in the state.
Yes, yes. Mr. Ganlok.
Ganlok was earlier in this case. I appearing along with Mr. BK Padi in this case. So lordship keep after 10 days. What is convenient to my
After 2 weeks on joint
Your
request.
lordship, interim order may continue.
Interim order to continue, joint request needs after 2 weeks. Yes.
Grateful.
My name along with Mr. BK Padi reflected in the
Currently hearing, but now everything is changed now.
Change,
Yes.
yes.
my lord, my name along with Mr. BK Padi name may be reflected in the list.
Yes.
109.
May please lordship. Lordship, with this matter, though the application was filed with a different cause of action, now the matter has been settled out and we are supposed to file a date may be given.
What is the offense?
Sure.
307.
Yes, lordship.
Charge sheet filed.
Is it? 2014 in offense. Charge sheet was also filed from 9/11/2014.
You filed this, I am just assuming it.
Yes, sure. So,
Okay, we'll do whatever.
One mistake.
Then I'll examine, okay.
On the last occasion, non-appeals was there. Interim order was there. If you understand, non-appeals has been made, so interim order is not continued.
No, but it's nothing.
Lordship, the order dated 4/4/2023 interim order was there.
4/4/23.
Yes, Lordship. Then after 19/4/2023.
2017, this matter is there,
Yes, sir.
and you are asking for time.
So the matter has now been settled. We will file joint affidavit to that extent because of the filing of this present application on a different cause of action. We have not filed any joint affidavit to that.
You file it when? Tomorrow?
Time may be tomorrow.
No, why? 2017 matter, you have taken a stay and then now you are asking for, from 2017, the stay order is operating.
Yes, Lord.
So therefore, I will not allow much time. Next week maximum.
Yes, Lord.
Give a fixed date, that is on 11th. 11th, either you come, all the parties should be here with affidavit, otherwise I will vacate the stay. And you argue on merit pattern. Right now. Stay in the present matter, the it is only execution of the NBW. Okay. I can set aside the entire NBW order and I'll allow you to appear in the court.
If they have settled, if the amicable settlement is there, it will be done over here, Your Lordship. The cost of whole entire can be
On 27/6/2017, the following order was passed. Inverted comma. There shall be stay of execution of NBW issued against the petitioner by the learned SD Jain and Jagatsinghpur in GR case number 471, capital A of 2014 till the next date appears. Next one. The said the aforementioned interim order has been in operation till date. The matter was taken up for hearing on many occasions. However, it was not concluded. Land Counsel for the petitioner today submits that the parties have settled their dispute and seeks an adjournment to file the joint affidavit before this court. Please the matter on 11th of this month. It's made clear that no further adjournment shall be granted in this matter on any pretext. Yes.
Okay. Should pardon to make a mention, item 103. I was not could not reach at the time on behalf of
Weekly. Yes. Next 109.
Okay.
110.
Written.
I have given the order of convenience.
Yes, madam.
It was taken in 160 case, madam, complaint case, madam.
Yes.
Here, madam, the fact of the case is that I have lodged a FIR. First, I have filed a 160 case.
Yes.
Which was directed to be registered by the police and GR case was registered.
Yes.
After investigation, a final report was submitted.
Yes.
Therefore, the agent accepted the final report without issuing any notice for filing of the protest petition. Because the final report was submitted in my FIR, a complaint case was filed by the accused in the GR case that since the FIR which was lodged by me was ended in final court, for which matter he has filed a complaint case alleging that his prestige, everything has gone. After accepting the final report, I have challenged that order in this honorable court. This honorable court, while citing that acceptance of final report, has permitted the petitioner to file a protest petition.
Right.
And I have filed a protest petition that is pending matter. If in the protest petition, if the Honorable Magistrate will take cognizance, then this proceeding that it has ended in final form will go, madam.
Maybe may not go, maybe tag together in the
basis is final form.
Yes.
Madam, your lordship will kindly see their complaint petition that is annexed to 1.
Madam, have you seen it?
I want to take some time, sir.
It's a complaint, it's a private party.
Private party, but the final form is filed and let them just, today only they've taken over. Now, you just read it. If you can render assistance, I'll put it next week. Let it be next week.
Next week, out,
1 week after. Good to meet you. You will be here next week.
So I am appealing for the informant in this case.
So, all right, because it is arising out of a complaint case, no doubt, but the final form was filed. Police is also involved in one or two. So therefore, they have only taken over. I'll put it one after 1 week. Okay.
entry order to continue.
Entry more to continue. 2 week के बाद फोटो प्लीज फॉर yes.
111 ମୁଁ ଭାବିଥିଲି କି ରିସର୍ଚ୍ଚ କରିବାକୁ ପଡିବ ମୁଁ ଆପଣଙ୍କୁ ଗୋଟେ ଆର୍ଗୁମେଣ୍ଟ ନେଇ ପଳେଇ ଯାଆନ୍ତି କି ଉପାସ ଖାଇନି
And now you are lucky that it reads.
ଆଜ୍ଞା ଆପଣ କଣ
Yes. Yes. 111 pass out. Yes.
That will the order of taking
Cognizance. Yes.
To enter initiation proceeding and order of cognizance.
Yes.
That is passed in a complaint case. That is under challenge with three-fold ground yours. First of all, that there is no sanction obtained under 197.
Yes. Who is getting
Is the complaint petition.
for
the informant, madam.
Here it is written that Madeleine counsel for the state is present. Okay. Anyway, he is present anyway. Yes.
My lord, I am for the complainant, my lord.
Yes, sir. Yes.
I have my challenge is on three-fold ground. First of all, is that these are the petitioners.
Yes.
They are the employee of distribution company. They are public servant, and no sanction has been obtained. Second fold ground is that there is a bar under section 168 of Electricity Act 2003 for initiation of proceeding against the person acting in good faith. And third ground is there is a statutory requirement of recording the initial
Second ground, good faith ground is a mixed question of fact and this thing. That
I will show.
Yes.
The third ground is that there is a statutory requirement of the London magistrate to record the initial statement of the complainant under section 202 CRPC also. That has not been obtained. And the complainant refused to give his initial statement. This is a fact, Lordship.
This was in third ground first.
Miller.
Third ground first.
Yes, you will also kindly glance the complaint refuse, annexure 7 that is under challenge.
7.
It's starting at page 39. The entire order sheet I have given.
Yes. Which order?
I have challenged the order dated 24 2000.
Where he says that I will not.
Yes, page 40, Lordship.
Page 40.
Order 17-4.
Yes.
2017. Advocate for the complaint.
I memo stating that the complaint doesn't want to evidence under 2.
This statement has not been recorded.
Yes, sir. Mr. Rai.
My lord.
There is no inquiry under 202.
My lord, your lordship may allow 7 days of time, my lord. 2017 matter, the file is misplaced. Next week, your lordship will say
202 inquiry is not done. And volunteer statement made by the complainant saying that I will not record any evidence.
My lord. But there another thing they are saying that 327 is a sessions tribal offense.
That is something.
This first ground, the third ground first to satisfy me. On that ground itself, I think he has a case.
Keep it to Friday otherwise, man. Coming Friday.
Okay, he is not prepared. He is not prepared. Yes, on the request of Mr. Rai, SSI, then counsel for the opposite party number 2. Opposite party. Means the matter of the week. Yes.
Opposite party 2 suit.
Yes. The interim order is there to continue to continue 3 weeks for
problems.
Yes.
113.
Yes, sir.
Charge sheet filed, your lordship, there are cognizance taken, case 28. 28, my lord. No, 20 is the order in claim, page 27, my lord. Yes. 27, 341, 323, the cognizance taken. Yes. Order dated 6/1/2011. Now on 12/12/2015, a petition was filed by under section 2, 321 by the state matter prosecution by due permission to withdraw the proceeding. So accordingly, it was allowed. That is at page 29. 29, my lord. Yes. In the above background and premises, this court is of the view, last but one paragraph. Yes, this is a fit case and suitable case to comply the direction made in the letter and memos communicated to this office. Accordingly, that is state's communication, the letter magistrate is referring to. Yes, then what happened? It is allowed. Now, my lord, your lordship dates are very important. This is allowed on 12/12/2015. Yes. In the meantime, he had moved this honorable court in an except 5. Page 30, next page. Yes. Here, that was the WPCRL, my lord, retreats and criminal single bench matter was going to be, was being taken this way, and reading course of hearing, learned counsel for the petitioner prays to withdraw the petition, the liberty to move the court below by a protest petition as provided under law. This relates, this is order dated 8/1/2013. My matter is being withdrawn in 2015. You are the informant. No, I am the accused. Informant moves this by him. Yes. So he gets liberty. That was in 2013, but this came to be withdrawn by the prosecution on 2015? No, that is 2012 we read it out. I possibly 2011 is the where is that? Page 29.
47 is the first point.
15. 112 Yes. Yes. Yes, I got it. 15. The letter magistrate takes cognizance and goes beyond the original FIR, charge sheet and all that, and it takes cognizance of 341, 323, 325, 294, 506 IPC. Be that it may, I was this one of the interim order is operating. Now, question is for your lordship's consideration is whether after 321 this is maintainable or it is come too close. Prima facie is not maintainable. I think so, and I am supported with some judgments also. Yes, are you ready? You have the entire file with you. No, instruction by instruction number. What instruction? We are I go to it and 1977. Yes, see the judgment. 77 Supreme Court 357. 321 application is already been allowed. Yes. And 21 Supreme Court 3954. AIR. Both are AIR. You got it down? And 321 is clear also. That section is clear. Correct. Public prosecutor can move the application. And it is with sanction from the state. And the application of mind is there. Yes. Application of mind is there. I've seen that public prosecutor has applied the mind and thereafter move application which is allowed. Legally allowed. That's the reasoning deviation is the state which that is referred. That is referred to. First paragraph only. Peruse the petition at 321. Letter dated 11/2015. Again, Home Department such and such. Yes, madam. Get ready on 12th or 13th you tell me. Because it's small matter, we will think it up. 13th. I am protected by an interim order. Yes, interim order. Continue. It's made clear that no further intervention. This is a question of law. You just answer it. He is relying on the true judgment. Give the citation. In 123, there is a connected matter which is not related to the main matter. I think it has been taken after lunch for compromise. So I will argue that separately, madam. You give the citation first. I gave you? Yes. I did it. Yes. But I want one matter 121. I am ready, but the other side counsel rang me up and told Rajiv Rathar that he would sitting that time.
Well, I am on VC. My learned senior is mentioning I had made a request in the morning. We are filing an objection affidavit. We are requiring that.
120 na?
121.
I had only planned November, outside checkup. Let it be fixed time first week of December, last week of December. In the meantime, Mr. Rathod, to file additional document. Additional document you want to file?
File an objection to the petition. Objection.
Objection. The matter the first week of December. You want to continue. Not best. Thank you. Okay. 16 on request evidence and 15 not present. I was not present if the matter has been posted to next week, but with the permission of this honorable court, I would like to argue this matter on item 84. 84. CD called for. It was first time they are coming. My lord, item 119, my lord, 117, already 117 there. So that the thing there is a point of law and the argument point of law. 117. So it was ready 19. That was I would have you have a natural naturally. You can use the board production next week. Next week. Next week, go to week for it. Go to prepare. Same for 119. 18 models to continue. Same for 119. All 18 models are to continue. Yes. Same for 119, my lord. 19, our learned senior had asked me that we will seek an adjournment because of the only for 2 days I am accommodating you. Thereafter, no accommodation because see, these are matters 2019 and all. Only fix a date at 2 p.m. my lord, I request. Oh, no problem. Pass over and take it. See, if the matter is listed anytime you can come and argue. My lord. What happens is if I indicate 2 p.m., the entire reach is getting disturbed. So you send someone, yes, ma'am. Who can ask for a passer, I'll take up at 2 o'clock. Yes, ma'am. You will achieve this fix. Yes, yes. 121, na? 190. 190. 114.
Item number 120, so other connected matters are there arising out of same affair and it has been adjourned to 20th November. So it will come.
Matters adjourned to 20th November. 20th November. 120. 120. Along with that. Yes. 120. Yes. Yes.
Daughter and son are suffering for not getting the pensionary benefits. May I pray your lordship may kindly please take it up.
Which year appeal?
2008.
8 appeal.
And it was hard price, different code, but due to the change of the
Particular, I will include that.
yes, yes.
Take, madam, please take it. Take it and just take it and when Jyoti will come and take it. Yes. Yes, pass over.
Pass over item 51.
Yes. Last topic in my note. I have making committee to the office, but it is petitioner case, commandant of. And it's, I'm telling you 197, your lordship told me, I don't believe. Now I'm, so your lordship, for this case, I need details. Your lordship kindly see.
You are talking about 51 item?
Yes, madam, 51.
Yes.
Your lordship kindly see the medical report, madam. If you can see.
Yes.
Going by the informal matter, lordship kindly see the unit for going and the prisoner in the valid compost. Lordship can see the night.
51 no, 51 my lord, your lordship may kind. Your lordship may kindly see the cognizance order. Your cognizance is the year of 2021, my lord. 21. Now we are on 2000. What do you say now? I think we have to 21. I have 21, 91. That is the stage that we should have.
It is the cognizance. I am conducting the case.
Okay.
I am conducting the case.
Then we see the cognizance is taken under section 354, 294, 506, 308. Every time something yes, very different. Yes, you have a chance. Yes,
So you can see the occurrence in the Settlement Committee of the Kanta. The occurrence is of 5/10/2019. Now we are fixing the report of this IO in the case. Defects in the charge sheet. The IO says big sense of the case is that 5/10/2019 the complainant 7/10/2019 the Rogi Nayak, the complainant, age of 25 years, daughter of Markanna Nayak of Dangarpura, yes, Muriwal Bolangi approved appeared at PS, presented a review report on the.
Where are you reading?
You investigation report, madam.
Huh?
You investigation report, and submitting does it take matter?
You have filed that.
Page 12 matter. So the charge sheet is submitted matter. Page 12, I'm reading it from page 12.
Page 12, 13 and all are statements.
Charge sheet is charge sheet.
Which page, sir?
Page 12. My page 12.
No. FIR starts from page 7, Annexure 2. Thereafter, all statements.
Charge sheet not.
All statements. Charge sheet is not there.
You must. I think
Because you do, these are the statements. 161 statements you have filed.
I will submit the charge sheet. I will
File and give a copy to me.
I will file that.
Let counsel for the petitioner seeks an adjournment to file additional document.
Next Monday also.
Let him do so within a week, please, after 1 week. Yes. Yes, next.
Case no the last case was disposed of for questionable cognizance. Yes, in this case, lordship directed to pay the cost of rupees 5,000 each to the opposite party of 2 and injured within a week. But on the same day, they have received. I have filed joint affidavit and money receipt. And this in course of the day. And that's not really reflected in the order sheet due to certificate. That order. What have you moved? You moved the application. Yes, madam. Where is that? Yes, flag W. Yes, madam. What do you want in this application? And in this application, madam, your lordship, as per order letter 4/10/2024, the last portion, my lord, directed to modify. That's what we are asking in the application. Petition was request. On the subject to payment of a cost 5,000 rupees. Now, already I have deposited. Where is that? On the course of the where give the proof. Right. Certified copy. By order dated 4/10/2024, the FIR got PS case number 577 up for 2015, corresponding to GR case number 1282 of 2015, pending in the court of additional STGM Khurda has already been passed, subject to the petitioner paying 5,000 petitioners paying 5,000 rupees as a cost. The petitioners have already deposited the cost and submitted the proof of deposit of these the said amount, which is taken on record. Where is the proof?
Joint affidavit and money receipt. The certificate copy of the certificate.
Where is money received?
Yes, madam. Then for page 4, money receipt.
4. हमको किसी कॉपी में भी देना चाहिए.
Money receipt or charge sheet. Already on the record also.
Please taken on record. Dispose.
In this case, sir, that yes was 2023, but 22 has been mentioned.
Where?
They have pressure had 22.
You have written.
Yes.
Yeah. Correctly didn't give it.
Yes. A record.
Given a record application allowed.
Yes. Okay.
So, yes, even application has been resulted in here the case the present petition charge sheet on 147, 148, 148, 506, 222, 149, the petition, there are several
28 persons.
22 concerned there, my lord. And running to 9, the questionnaires,
You want only 1, 2, 3, 4.
yes, my lord.
4 witnesses.
Yes, my lord.
Show me their evidences.
And I'm running to 9, the voter questions, my lord.
Better to verify whether the person is truth or not. You should have given this copy of the deposition. Where is the copy of the deposition? Why have you not cross-examined them? And but the order says that he has been cross-examined length, and thereafter, my lord, he has discharged and subsequently at the bill tester, he has filed the petition.
Mental questions, my lord. It said, I am left out some mental questions, and that is why I am running to 9, my lord. I have given those questions. Questionnaires are from 1 to 20, and sorry.
You have, come to the page 9. You have suggestions, 5 suggestions, 20 questions you have filled.
Yes, my lord.
These questions to be put to which witness?
1, 2, and 3.
All of them.
One,
Same question will put.
3, 4. Yes, my lord.
Same question.
Yes, my lord. It's a, my lord, it's a 22 charge sheet, persons have been charge sheet, my lord.
Who are these witnesses?
My lord, I am seeing. One is one corporate knowledge, my lord. And
I'm not asking your name. I'm asking what is their role. Are they eyewitnesses? Who are they?
They are present at the spot.
Show me from where you got that.
I'm the question, my lord. Questionnaire, my lord. Question, my lord. Run 9, my lord. Who had the administrative prison language putting the fact and how many persons were present there? Can you speak the name of the persons who are present at the time of occurrence? Which questions to be put to the person?
See, the problem with you is this is a second bill, second application under section 311.
Yes,
first it was allowed.
Yes.
Opportunity was given in 2018.
Yes, sir.
And you did not avail or avail, I don't know. Nothing is coming from that is second application for the same to be called. One witness, how many times
Well, I thought the last time.
why are you not first recall you have already done?
Man, I have not put some relevant questions. I am giving the.
What do you have to say? Tell me the reason your application doesn't say anything. Come to the objection. Come to the objection at page 12.
Yes, ma'am.
Para 4. How will you get out of it? What is the problem?
Yes, sir. Second recall application, abuse the process block. That is the written matter.
You are not reading it because it is very inconvenient to you.
Yes, sir.
Loudly read and answer it.
But all the other mentioned witnesses for recall have been already recalled in the year 2018. Yes, my lord.
which is 5 years from today.
Yes, madam.
This is the second application under 311.
Yes, madam. My lord, my solution is that, my lord, here, my lord, 24 persons have been charged, my lord. It's the life of the 22 persons, my lord.
Right, you have a right to defend yourself, but this is the, you are not, in the application, you are not saying anything. Just
Only one.
out of this 4 witness, which witness is very important for you?
My lord, it's some, witness number 1 and
Twice different example. What is the stage? That is also not normal.
out of 17 witnesses, 13 witnesses have been examined.
And 4 more witnesses are within that. Are you sure?
Yes, my lord.
You think over PW 1 and 2 will give last and final opportunity with some cost.
Yes.
One opportunity. But it is stated in the order sheet, my lord. That was change the law and now wiser law is there. One opportunity, see, they are the accused. Prosecution evidence is still going on. And the accused have indivisible right. And they have changed the law and whatever. One opportunity with some cost. This second opportunity. Maybe second, but what I can understand if this prosecution evidence, then I can understand. Now prosecution witnesses are being examined. So one opportunity, 2 witnesses. He is asking for 4. He listed about 20 questions. He doesn't say which question to be put to whom. I don't know.
And also deposition copy is not
filed. Not
whether the question is put or not, that is also
that is another good thing. Incomplete petition.
One chance maybe.
deposition copy टा दियो next week next
Yes, that's a better idea. You do one thing, you file the deposition copy. If you don't file, get it at least. Give me a copy. Let us see whether these questions are relevant or not. If at all it is relevant to which witness to be put. You are off the cuff, you are saying 1 and 2.
Yes.
It may be relevant, maybe 3, 4 also. You never know.
Yes.
So let us examine. With next week. Next week. When you copy of the evidences, supply a copy. Yes.
55.
Yes.
60 lagi bole.
55. First time. Non-appeals on the second call in the interest of justice. Non-appeals for the petitioner on the second call, which is an appeals for appeal for the state in the interest of justice adjourned to December. Yes. 123.
123.
You got that application. Ranjan Das is present.
Yes, sir.
No, the second affidavit of Niharanjan has filed. Petitioner is a
paper for mother lordship.
That is 4565.
Members.
Yes, Mr. Sharma, you wanted to say something.
122. 23, sir.
I know, I'm just taking out of turn because
Sorry, I saw the board.
I understood it.
I got confused.
Yes. Right on, at the instance of opposite party number two, the first one, see, first 123. You do 4565. 4565. Kanchan Das, huh? Kanchan Das, one, the Kanchan Das is the mother-in-law of opposite party number two. Second,
हमारा संग है भूल लेंगे
ठीक है, सुशांत इज ब्रदर इन लॉ, सुशांत इज ब्रदर इन लॉ, ठीक है, ब्रदर इन लॉ, ये सेकंड है, ओके, हस्बैंड नेम, हस्बैंड ठीक है, लिखो, अब तो लिखो, फर्स्ट लिखो द इंस्टेंस ऑफ अपोजिट पार्टी नंबर 2, FIR number 2 came to register against also. And any weakness is the petition will solve. Mother-in-law, besides the mother-in-law against the application. The opposite party number 2 is present in the court today. Being represented by lawyer and filed self-registration copies of Aadhaar card to establish their identity. She has however, the petitioner, who is the mother-in-law of opposite party number 2, is not present in the court physically, though represented by her counsel. Her son, Nihar Ranjan Das, who is the petitioner in the connected matter, being CRLMC number 3700 of 2024, has filed an affidavit inter alia stating that the petitioner in the instant case is his mother, who is 60-year-old. She has been suffering from severe arthritis and unable to move. Therefore, he could not be present in the court. On her behalf, she is seeking exemption from personal appearance. The affidavit is taken on record. Personal appearance of the petitioner, Kanchan Das, who is the mother-in-law of opposite party number 2, is exempted. Personal appearance exempted. Item. Where is that Kanchan Das? Where is Kanchan Das? The opposite party number 2, who is present in the court, on query from the court, stated that she has already received the permanent alimony, agreed permanent alimony of rupees 2,75,000. The parties have settled their dispute 270. Parties have settled their dispute through mediation, and subsequent thereto, the opposite party number 2 had applied for the opposite party number 2 and her husband applied for a dissolution of their marriage by mutual consent. No, expected order was granted. In the instances of husband.
Who has filed that? What is that?
Husband.
Where is that order?
That is not.
Where is that order?
No, that is not in the.
You people don't file anything. Everything is assumed. Are you sure that they have divorced?
Yes, sir.
Tell me the court number, date when the divorce decree was passed, something of that sort. What kind of petition you people are filing? I don't know. Twice it is adjourned. Now get an affidavit. Everything the court has to advise. I will impose cost now. I will not leave it like that. I will definitely impose cost on these people. Let it be. Let them pay something. Yes. Yes, tell me.
CP number 405
date, CP number, which court is that?
Family Court Cuttack matters.
The Family Court Cuttack, in pursuance thereto, Family Court Cuttack, in CP number?
CP number 405 of 2021.
On
2/8/2022.
2/8/2022 has passed a decree and dissolving the marriage between the opposite party number 2 and her husband Nihar. What is that? Nihar?
Das, Niharanjan Das. Niharanjan Das. Niharanjan Das. Where is the joint affidavit? Affidavit is there. Affidavit. The mediation report, the mediation, High Court Mediation Center, report of High Court Mediation Center, Cuttack, dated 3/7/2024, 24, is enclosed with this petition. The terms of the settlement is enumerated in the said mediation report, which reads as under mediation report. That's the mediation report. Taking into consideration the aforementioned mediation report and the partial compliance of the terms, compliance of the terms of the mediation terms, I'm inclined to entertain this petition. Petition and petition for the domestic appealing for the state settlements that since the parties have arrived at a settlement through mediation process, there is no and the dispute is essentially arising out of a matrimonial discord. There is no legal impediment in quashing the FIR. So after all the things you take dancing and all. So I think next time, next matter you write down this. Next, 4575. 4575. Primary good the petitioners are the brother-in-law and sister-in-law of opposite party number 2. Petitioner number 1 is present in the court today, being represented by his counsel, and had filed the self-petition copies of the Aadhaar card, which is taken on record. However, petitioner number 2, who is the wife of petitioner number 1, is not present physically. Petitioner number 1 has filed an affidavit dated as of date 4/11/2024, inter alia, stating that his wife, the petitioner number 2, could not be present in the court because could not be present in the court because he's 4 months back he delivered a baby girl, and who is suffering from fever. On her behalf, the petition number 1 is seeking exemption from personal appearance. Now, for the reasons stated in the affidavit, the personal appearance of petitioner number 2 is exempted. Affidavit is definitely. अवतार निहार रे तम कर दो 370024 3700 3700 ही जजमेंट. ठीक है, हेलो, ठीक है. कॉस्ट यू पे 1000 पे लॉर्डशिप हस्बैंड कर दो, निहार कर दो, subject to paying the cost of 1000 rupees to the opposite party number 2. Was yes, 1000 rupees. अरे गोट्रे का कर दो, हस्बैंड रे निहार वाले में subject to paying cost of 1000 rupees to be paid to the opposite party number 2. Was yes. Detail. Yes, sorry.
61.
नहीं इधर कनेक्टेड अच्छी लास्ट टाइम.
That is wrong. No, I want to do that better.
60 टा 60 टा
Rest matter one.
60 टा
Which one? Which one? 3724. Please and then I'll take it up. I'll take it up. I'm taking other matters. This is B tag. In fact, wrong with tag with that. Let me take it up. It was at the 4 o'clock. Wrong here. It was other matters were taken up. Okay. What is this matter is about? Check bounce, your lordship.
23, no? Item 123 last item there. How it is tagged? Maybe here was wrongly noted by the most of the master. Yes.
Wrongly tagged, yes.
My lord, this is I am the accused there. A cell deed was executed by the informant, your lordship, that is annexure 1. If your lordship turns to the concept, the page. Yes. Entire consideration amount was paid, that is at page 12. For 36,06,000 for paragraph 2, my lord. Yes. And whereas the vendor have received the above said amount as full and final consideration from the vendee. Where is that? Page 12, my lord. 12, second paragraph. 1, 2. First is part paragraph, second is 36,606,000 is the cost, that is prominently mentioned, my lord. Third paragraph, and whereas the vendor has received the above said amount as the full and final consideration from the vendee towards sale of the below mentioned landed property in presence of the following witnesses. The lordship finds that. Yes. And also amount was paid. Now, that is sale consideration. Sale consideration. Page 23 is the money received to that effect. Separately. That's on stamp paper and all that, your lordship. Yes. Now, 2 checks were given as security. Instead of returning those to me, the gentleman puts it into the account and bounced. He says that notice has been served, but in fact, I have not received any notice. Now, 138 initial proceeding has been initiated, and the allegation here also look at the page 31. Yes. That is the notice, my lord. Yes, demand notice. Page 30. That though the sale deed at page 3, third paragraph, it has been written down the vendor received the above said amount as full and final consideration from the vendee towards sale of the landed property, but you know that they actually had not happened. Rather, in good faith, my client had relied upon you and full and final consideration amount after execution of the sale. That's what he says, that you have not paid full and final consideration. Well, I will check you might have paid, which has been given. That was prior to this, I had given my lord this year. How will I come to that conclusion? You say it is a security. And he says that the amount which you have paid, part of that is a check. And how would the money be given? There is no mention about checks in this. How will I know all these things? Yes. At this time, it is difficult to know. So, lordship, let me take out notice. Don't ask for stay. Because it is 138 meter, therefore I am issuing notice. I need to know mediation report. I have to do tomorrow, next week. Tomorrow, sir, next week. Notice notice has you. I am issuing notice next week. Yes, issue notice next week. Can bring in if it is part of unless this goes to mediation, fix what some bring in and send to mediation. Yes, I will take a notice. Issue notice to and next week. Put it on 40th. You bring him. I will seek for an adjournment with the trial court if it is. No, you bring him. No. Even 14th, if it is listed, nothing will happen. I am not on that. I will seek for an adjournment. What is the case? You tell me. You will not appear. I will appear. Oh, then appear. You will not appear. That is what I am submitting, my lord. I will seek for an offenses. And I don't even I am not about the my lord, the madam who is that. Are you sure that by 14 you will be convicted? No, I will seek an adjournment because bring him. I will put it on 12th. File the process 12th. Bring him. Let us put an end to it. On that date, interim application will be considered. Yes. Issue notice on interim application as well. Yes. Yes.
61. May I please bring
Now, glance to page 18, my lord.
Yes.
In page 18, towards bottom order dated 15/9/2022.
18, 18?
Page 18, towards bottom. There are 2 orders, my lord. One order is 20 August 2022. Another order is 15/9/2022.
Yes.
My lord, informant is absent. Advocate for the informant files the protest petition put up on 18/10/22 for further orders. That means the case was posted by the Honorable Justice to 18/10/2022. But On 28/9/2022, the case was taken up by the learned STM and disposed of.
1810 it was fixed.
Page 19. Mala kindly have a glance to the order passed by the learned STM. The case record is put up today as fixed, that is error of record. The complaint present in the court today. Summons have been issued to the families of deceased by the order dated so and so, but the SR of the same is not there till then. The complaint overall stated the issue of living alone for which the other case received the death blow of Judicial and lost the affair.
What happened in that then?
Then subsequently the protest person was dismissed under section 203.
Yes. See, on the matter was taken up on the 20th of August and it was adjourned to 15th September. On 15th September, it is adjourned to 18th October.
That order is.
And in between, no, you see, page 18, and instead of waiting till 18th 2022, it was taken up prior to that 28th September and
On some occasions there is a protest in advance put up the record.
He's trying to explain. Yes.
ସେ ଅର୍ଡରଟା ହେଇଥିବା ଆପକେ ବର୍ତ୍ତମାନ ତ ଜାଣିବା କଥା କାହିଁକି କାହିଁକି report.
Then what he's trying to say is in between whether there is any order.
No order. Madam, the culprit report from the order STM. There is no order.
Apart from that, my lord, a lot of it also.
Madam, from the complete outcome. Clarify.
The affair was lost on the one. The lordship may kindly see. Triluchan Gohir. He has filed the affair that stating that there was an accident. Then he was seconded. Then my lord, the police investigated the matter. Anybody has not come for that reason. Final report was submitted by the guy. On the basis of final report, then Lord Magistrate has, for acceptance of that final report, he has issued the notice to the informant as per the law. Then on the basis of that notice, that person was appeared and final report was submitted. No, not submitted. Then the court feels that his family members may come to the court and stated because they are the aggrieved party. Then notice was issued there. They have not come. Thereafter, my lord, the court has passed this order and the informant has come. For that reason, the final report was submitted, accepted. Then he has filed a petition. My lord, he is not the informant. He has filed a petition under section, but without filing 1cc case, my lord. He has filed a protest petition in that affair where the informant is somebody else, stating that I am the my lord, son of that deceased man, without supporting any document whether he is son or not. For that reason, disbelieving that whether he is son or not, the law and trap court
he is questioning the locus standi of yours.
That order also reflected, my lord.
Yes.
That order reflects.
What locus standi you are? You are not the informant. Can you maintain a protest petition? That's what this is.
I am the son of the deceased. Another thing, my lord.
First this thing you overcome. Another thing next time. Overcome. Can you maintain a protest petition?
Yes, my lord.
If you are not the informant and you are the son of the deceased,
I am the
proof also you are not able to give.
I am the
without any document. By
that the petition is the son of I have given the protest person kind of a glance.
Yes.
Page 20.
Yes.
That the petitioner is the son of late Fagunjal who died in a road transplantation. That the inter-alia is the affair in this case that late Fagunjal was driving the tractor of the infant by distance also. By that time, the one of
have you filed MACT?
Madam,
have you filed MACT? Have you filed?
Yes, sir.
Where is that?
That okay.
You show me if you have filed an MACT 166.
Madam.
Then you may have a case.
Yes, ma'am. I have filed the MACT and another thing, madam. Madam, call for a report. I have trial court experience. My friend has none. If any case in people, the runner trial court take time. The prosecution will find the person or the accused will find the person or any agreed to that one. But the order sheet doesn't.
In the order sheet it is written that the matter is taken up on the application or something that sort.
My lord,
it's not there.
So, madam, the call for a report
And in the meantime,
Simply issue notice, let us see.
and so in the meantime, I will call the certificate government for this. You may come next week.
You must produce what you call
66 petition.
166 petition.
Whenever I made a report from the student, why the case was people? No reason. Let us see. Human and manager report in the sufficient letter. Report we call for from the student.
Why should I involve the court right now? I'll simply issue notice, let him.
Why the student? But in the main,
Primary issue is whether your son or not, that is not.
You can collect CD from the police manner. You cannot collect the order sheet from the non trial court. So if minor will call for a report, and produce the certificate.
The trial court says that further the complainant has not submitted any document to establish the fact that he is the son of the deceased. This is one of the ground. If you file 166 petition, if it is maintaining is going on, then you have a case to
So, and our friend may collect the CD and other documents, and we call for a report. Why the case was preponed on 15 on instead of 18?
Well, I will not involve the court right now. I will just issue notice. Written will also. And then counsel for the petitioner seek leave of the court to place on record the additional document. So when next date appearing after 2 weeks there.
Next week I will.
Next week, yes.
Next week I need as well as
Next week may not be possible. But it will be.
I will
19, 20, any day.
I will pardon.
Yes, check it.
I have to give it.
Yes, check.
So,
70.
You give your convenient date so that I can.
yes, 18.
18. Find the process immediately.
Yes, immediately. Okay.
Yes.
Yes, my lord. 17, 71, my lord, may take up together, my lord.
Yes.
My lord, in 70, my learned senior is appearing in 70, and I am appearing as informant in that case. Both the matters have been amicably settled. And my lord, in 71, I am appearing for the petitioner.
What are the offences?
My lord, in 70, the offences are 498, 294, 323, 376, 506, 34, and
498 is not there.
498 is there, my lord. Your lordship may just peruse annexure 3, running page number 29.
There are two FIR. 493
My lord,
and 573.
yes, my lord. In application, in the first application, my lord, that is 3597, item number 70. Lordship may just have a glance to FIR number 573 of 2022, which was read, my lord, is to the present opposite party number 2 in that case, and petitioner number 1 in the next case.
Don't mix up. You know the effect of your case. I should know it. Item number 7597.
2590.
You are seeking crossing of the annexure number 2.
Annexure number 3, my lord.
No, sorry, annexure 3. Okay,
Yes,
annexure 3. Here, who is the informant?
My lord, in that case, Samikha Rani Jena is the informant.
Okay. And in the other case, 71, let us see.
71, my lord, the Santosh Kumar Panda is the informant in that case. Case and counter case, my lord, against both the families.
Samikha Jena is the accused there.
Yes, my lord.
Indeed.
Yes, my lord. Samikha Jena and other family members.
Sarat Chandra Jena.
Yes, my lord. Sarat Chandra Jena and
the informant is the Santosh Kumar.
Santosh, my lord.
This FIR is?
This FIR is 493 or 2022.
Okay. Cross FIR.
Cross FIR. Okay. So both the matters.
Where are they?
My lord, all the
first FIR,
first case, my lord, that is 3597.
498 होगा.
498 total. Santosh Chandra Panda.
Yes, Santosh.
My lord. Yes, sir.
Santosh and Savita.
76 is your.
376 subsequently marriage certificate टा भी annex करायची.
Okay.
Okay,
I understand. Santosh Panda. Yes. And Savita Panda. Yes. They are the
mother-in-law is Sabita Panda, and my lord another
Santosh is husband.
Santosh is husband.
Okay. Swapna? Yes. Other data say other. You just ask Swapna. Swapna. Right on. At the instance of opposite party number 2, FIR number so and so, if code election, 3594. So, at the instance of opposite party number 2, FIR number 573, next 3. PS case, Hon'Ble PS case number 573 of 2022.
Hon'Ble PS
22. The petitioner. Petitioner number 1. In this, Mr. Mahapatra, in this first petition,
yes, madam.
Santosh is the husband of opposite party.
Opposite part number 2.
Santosh petitioner number 1, 2, and what is Arab Kishore? Arab Kishore. Petitioner. He's the father-in-law.
He's the father-in-law.
All the petitioners are present. Representing the person, being represented by their counsel. The opposite party number 2 is also presenting the court and being represented by her counsel. They are being identified by their respective counsel, and they have also filed the self-registered copies of the Aadhaar card to establish their identity, which is taken in the court. The petitioner number 1 is the husband of opposite party number 2, whereas petitioner number 2 and 3 are the mother-in-law and father-in-law of opposite party number 2. The dispute is arising out of a matrimonial discord. Investigation is over?
Investigation is
over. Charge sheet filed?
Charge sheet filed.
When?
My lord, charge sheet has.
What did it say?
My lord,
stage
my lord, charge sheet has been filed and
cognizance taken.
Cognizance, my lord, charge sheet was filed on.
After investigation, charge sheet was filed on Premature for
and that
offenses
under 498A, 294, 323, 376, 506, 34 and 4 of DPI.
4 of DPS. Okay. Okay. When the matter stood thus, the parties have settled their differences. What is the dispute they married?
Madam, they have married on dated April 2022, and my lord, the recent progresses, they have filed a mutual consent divorce, and that is right CP number 614 of 2024, which is in the file of Maharashtra Family Court, Bhubaneswar, which was filed on 38/2024.
The petitioners have filed
petition number 1 and opposite part number 2.
Certificate marriage certificate dated 22 of 5th April 2022 issued by the marriage officer Hon'Ble under section 13. Section 13 of HML, Hindu marriage. It indicates that petitioner number 1 had married to opposite party number 2 on 5th April 2022. However, due to matrimonial discord, they have now decided to separate. Accordingly, they filed a petition
number 614 of 2024.
Let me complete this sentence. Filed a petition under section 13B of Hindu Marriage Act before the court of.
Well, it is not 13B, it is under section 28 of Special Marriage Act, because the
28 of Special Marriage Act, they should.
In the court of Landed Judge Family Court, Bhubaneswar.
Landed Family Court, Bhubaneswar.
Madam, it is pending.
Pending.
It was filed on 38/2024.
Pending. And what is the terms of settlement?
Terms of settlement is, my lord,
how much you are paying? There is a child also.
Madam. No child, my lord. No child. No, my lord. He's not the child of the opposite part number 2.
So what is the terms? What are you paying here?
My lord, no alimony, my lord. It has been mutually agreed.
Child is not,
My lord, child is not of the opposite party.
I understand it now, but what is the term? Why she is giving divorce? There must be some permanent alimony or something?
My lord, permanent alimony of 2 lakhs.
You are not sure about anything.
My lord, 2 lakhs, my lord.
Just now you said nothing.
I beg your pardon. I beg your pardon.
13 is also not allowed.
My lord, it is pending, my lord.
Pending, let it be allowed then.
ସେ କହିଛନ୍ତି ବି ପଇସା କଥା ପଇସା କଥା
Let it be allowed. What is this?
2 lakh रहेगा.
Let it be allowed. I don't. I'll examine that personal appearance. Let it be allowed. Then you come. With a degree you come.
Reflect that.
With a degree you come.
My lord, may just observe.
Because you people don't file anything. Everything you throw in the court. If I ask you, say, make some. You are playing with the life of some lady, girl. She married, now separated. You don't know whether you are paying anything or not.
There is talk.
Don't do it so casually. Somebody's life is involved.
They have now decided to separate accordingly. They filed a petition on the 28th of December that before the court of judge.
Which is pending, yeah? Which is pending to be decided. The parties have also filed affidavits before this court. Dated affidavit before this court dated 4/4/2020. 4/4/2000. In view of since the mutual divorce petition is still pending, and the terms of the settlement is yet to be executed. I'm not inclined to allow the petition at this stage. Accordingly, the petition is adjourned to when it is listed.
My lord, may keep it to any day in the
when it is listed, 28 petition. That also you don't know.
My lord, may adjourn to 2 weeks after, and your lordship may just.
And then you ask for adjournment. You will tell me when that application before the family court is pending. I'll give a date thereafter.
My lord,
ask her. You see full instruction. What is this? Ask her.
Just file for the date report.
My lord, after 6 months, so my lord may just reflect one thing in light of Amardeep Singh, so that it gets convenient for both the parties, my lord.
I will allow that petition also here. When you make a statement, you are in the High Court. Make a statement.
There is a waiver period of
that petition is pending. I will wait the pull-up period here. What are you talking?
May consider
what kind of submission you are making? Pull-up period, you have to make a prayer there.
I will make a prayer, my lord.
In a mutual petition, without any thing, I will allow that pull-up period also. I will wait.
I'm not praying for that, my lord.
That's what you just now told.
My lord, may just observe the
when will you move the application?
My lord, the date is 30 August.
You move an application there for waiving of pull-up period. And do it at come after.
But I will move that application just that.
Let it be. I'll tell you. Let it be on 6th of December. Okay. By that time you move application and get it allowed.
Manager just observe that that will just that I will make an application over there.
You do whatever. How can you? I'm sitting over advising you. What will you do? How will you walk and everything I'll tell. Least the matter on 6th December. 6th December on the next date of hearing, and the payment will be made there. But both of them have to come. She has to confirm the payment is made or not.
Both husband and wife will come the other
on the next date of hearing. The petition number 1, Santosh Kumar Panga, and the opposite party number 2 shall be present in the court. And insofar as the other in-laws are concerned, their presence is exempted. Okay? Very exempted.
Subject to my lord's approval,
If I had recorded my submission also, that would have helped a lot.
In this jurisdiction, I can't do all these things. I can't preempt the proceedings pending before some other court. Completely irresponsible job. You can't do that.
That's my
You move application there. Generally, these applications are moved there. I will be in urgency now. This take this advert copy and I'll do that. Yes. Yes. Yes, 73. 20. Yes. 70? 40. Non-appears on behalf of the petitioner, even in the second call, Mr. Vishal for the state, in the interest of justice, adjourned to next week or the non-appears, dismissal will be followed. Even copy of the petition has not been supplied to the state council in the interest of justice. Yes.
75. Here in this case, the petitioner who is not an accused or not named in the affair, her bank account has been seized. And kindly read page 17. The bank informs
17, huh? Yes.
Yes. Page 17, bank informed that we have seized the bank account
in freeze under section 102 CRP.
Yes. Yes. On the ground of economic offence showing CID crime branch, Odisha, Bhubaneswar. And annexure 3, page 18.
How are you related to the accused?
I am not anywhere related. But the account has been seized.
There must be something.
Yes, but page 18 is the affair. And here it is a very huge 14 crore in financial online fraud. And accused have already principal accused this current Singh approached this honorable court in bail application, where he has also said that I have already paid 2 crore something and I will pay rest amount there. So, but the petitioner who is no way connected and that her account has been seized. Might be some suspicious transaction could have been taken place.
That's right.
But how they can seize totally, completely? And I don't know how they can do because this fraud money might have been transacted through your account. That might be the reason. 102, they have complied with 102. No, 102, but I am not involved in Supreme Court says if I am not an accused. I am not named in the affair.
Supreme Court doesn't say that.
Yes, Supreme Court says that if you are not accused, your account will not be seized. Yes, yes.
Even if the money is transacted through your account.
If I am very happy, you should be happy that
under the rule of 120B, they have not made you accused.
No, that should be happy there. They cannot. They cannot do that.
If from your account the money is transacted,
through analysis, we have had, in our opinion, that a bad
which one you are reading? Which judgment you are reading?
That the Supreme Court judgment, this is,
yes.
German capital, para 11.
Okay. In our opinion.
Yes. Reading a decision entered by the lower court would show that the imposition of the bank guarantee and the freeze orders passed by the respondent were solely imposed on the grounds of criminal proceedings being allied against one Dharmesh Doshi, who is alleged to be connected to the appellant company. While perusing through the documents and record, it has come to our notice that said Dharmesh Doshi, on the basis of whom the condition of bank guarantee was imposed, has now been
It is regarding the release of the defrozen of the account on the condition that the bank guarantee should be deposited. In that context, the judgment.
No. Thereafter, they have said, in such circumstances, wherein the appellant company and the accused Dharmesh,
you seek instruction. Let us see. You seek instruction. At least after 2 weeks, let him seek instruction.
Short date may be fixed after 1 year, and the accused has already deposited the amount.
That is why I am saying if accused has already deposited in the account and the money, then what is the amount there in this your account?
That is not with me. Balance is, I have balance of 8,80,000.
8,80,000.
Yes.
Correct.
So I am a housewife. I cannot use my account.
You must be related to,
but found suspicious online.
How are you related to this accused?
I am not related. That is the company transaction.
kindly have a glance to how are you related to the company then? No, I am just saying because kindly have a glance to page, remember how are you related to the company? Are you not related? Page 21, the informant says that there are 125 to 125 bank accounts which I have requested your good self to freeze. 125 bank accounts has been seized. Out of that, my bank account must have been there. Yes, see 102 proceedings. Okay. And 102 also say they have to satisfy that whether I know this is, yes, this is common law. This is also Supreme Court says time and again. And Bombay High Court also fulfilled says this thing. These are admitted person. Why are you bringing Supreme Court, Bombay High Court? These are common law. Yeah, because she's a housewife. More than measure has passed. Charge sheet has already submitted. You will see. Just check it out. Short date, I feel short date. After 1 week. Yes, next. 76.
94.
Hello? 90?
94.
Okay. Yes, sir. 94, nobody is there. Non-appears for the petitioner on the second call, Mr. He appears for the state in the interest of justice. In the interest of justice. By way of last opportunity, the matter is going to 1 week to 2 weeks for the It's made clear that on the next date appearing, no adjournment shall be granted in this matter. Yes.
97.
Made to your lordships. Your lordships, 311 petition has rejected, your lordships. Your lordships require only what's the actual occasion, lordship. Allow the petition, but as the copy was not sought to the Vigilance Council, that's why it was adjourned to lordships.
311 applications.
Your lordships, I have paid for PW 6, 12, 14, 15, 16, 17, 18, and 19 lordships to recall. But however, I am confined to only my prayer to.
You forgot to write 1, 2, 3, 4, 5.
Your lordships, in fact, I witnesses 17, 18, 19. I only confined.
That is a better idea.
Your lordships.
17?
17, 18, and 19, your lordships.
17, 18, 19. When these people were examining.
Your lordships, in fact, beef was transported and they are not declined, your lordships.
What is this case? What is this case?
Just copy. Trial lordships for the accused statement, lordships.
18, 19, 20. You say,
17, 18, 19, lordships.
17, 18, 19. Show me their statement.
Your lordships, I have additional affidavit, I have filed, your lordships.
Yes, I am aware.
In fact, petition was filed without question, without any question, your lordships.
17, 17 was examined on
2017. In fact,
5/4/2017.
Brief was transferred from the Kotak to Deccan, lordships. That's
decline.
Declined, lordships. Hello, declined, lordships.
It's a case of decline.
सब तो डिक्लेयर करछन तपर से जो कहउछन जे एग्जामिन करिया पई इज द एमबीए by this time he must have retired तपर से जो
how will you secure their presence? That's another problem.
Your lordships is residing there, lordship. What is the address, lordships? On address for my instruction, lordships.
See, these people are already retired. How will you secure their presence? 2017, they might have been, somewhere. I don't know.
तपर से स्टूडेंट्स ना ऐसे क्वेश्चन जासो पचारछन आपण यू लॉर्डशिप काइंडली से पेज 9
examine seriousness of the
yes, lordships.
Where is the page 19 your lordship can see additional affidavit.
Yes.
Accused first owner की second owner. It is there. The comes in someone's name. Redaction of
document you will read.
Yes, lordship. So
सीता तो कहू
opportunity मिले कथा के चाहो
क्या करते
नहीं you have a right to defend yourself, doesn't mean that you. Therefore, I told you, you decide out of all the witnesses who are really relevant. I can allow that.
Only suggestion, 17, 18 and 19 verses, that's
Only 17?
17 and MBA.
How will you secure reach presence?
Lordships, he is working there, Lordships.
And 18?
18 also official witness.
18, let's say seizure witness. Seizure Lordship can seizure. I suggest you that you have prepared seizure list in routine manner only to harass the accused. What sort of
The court will verify if that is that are the relevance in their Lordship.
No, for the sake of calling them, if you want to call, you call. What is the relevancy? What is your age?
My age, Lordships,
If you sufficiently dragged it,
62 years. 62 Lordships.
It was withdrawn.
62 years.
311.
62 years, Lordships.
62. You have decided that before the conviction is recorded, you should leave the world.
No.
So that sufficiently prolong it.
No.
You tell me what to do. One opportunity, what to do? Three witnesses, one opportunity. Relevancy of the questions will be examined. Thereafter, they will summon. The trial court should examine the relevancy of the questionnaires to be proposed questionnaires. Thereafter, summon three witnesses. Give one opportunity. Okay. Petitioner is agreed by the order dated.
It is Lordships.
Order dated by Tensi, passed by the Special Judge Vigilance in Dhenkanal in TR case number 13 of 2017, whereby his application under section 311 CRPC to recall PWs 6, 12, 14, 15, 16, 17, 18 and 19 has been turned down. On the last date of hearing, the legal counsel for the petitioner had sought time to file additional document pursuant thereto an additional affidavit dated 17/9/2024 has been filed, including therewith the application moved by the petitioners under section 311 CRPC, proposing CRPC. In the said application, the proposed questionnaires is also been attached. At the outset, the counsel for the petitioner submits that he would not press the application insofar as the PWs 6, 12, 14, 15, 16 are concerned. However, he submits that insofar as the PW 17, 18, 19 are concerned, they are vital witnesses for the prosecution, further cross-examination and putting the relevant questions to them is very essential for his defense. Therefore, he submits that the application under section 311 CRPC moved by him, 17 PW 17, 18, 19 may be allowed. Mr. Maharana, learned counsel, vigilance counsel for the vigilance, by referring to the proposed questionnaires, submits that all the questions proposed to be put to the said witnesses are completely irrelevant, and the exercising of exercise to recall the said witnesses will be aiding to the prolongation of the trial. The full of the petitioner has been employing this ploy to delay the trial. The present case is pertaining to an FIR of 2005. Therefore, Mr. Maharana vehemently oppose the prayer made by the petitioner. I have considered the submission made by both the parties and perused the material placed before me. I am of the considered view that the petitioner who is facing criminal prosecution for offences under section 13(1)(e) has a indefeasible right to defend himself. Therefore, he is entitled to cross-examine the witnesses. Perusal of the evidence of the said witnesses recorded way back in 2017 reveals that none of these witnesses were cross-examined by the defense. Therefore, the prayer made by the petitioner deserves merit. Accordingly, the application under section 311 CRPC moved by the petitioner is liable to be allowed qua the PW 17, 18 and 19. Accordingly, the trial court is directed to fix a particular date to re-examine, recall the witnesses, the said witnesses. Available. See, three witnesses. Three witnesses. And after examining the relevancy of the questions to be put to them, the said available witnesses may be summoned for re-examination. The petitioner shall not seek any adjournment on the date to be fixed by the trial court. The petitioner, it is made clear that the petitioner is entitled to cross-examine these witnesses on the same day when they are summoned. If for any reason the witnesses could not be examined by the petitioner, the right to recall the witnesses forfeit the right to cross-examine the said witnesses. With this observation, the petition is allowed, partly allowed. Much of it, partly allowed. Yes.
That 75, that is OPID matter. I will solve a copy on OPID council.
Please do that. Yes. 75 OPID council. Okay.
Right, so I'll take one care.
Yes.
111.
Yes.
111.
What is the position? Last 2017. Hmm?
27 or 14.
27. Remain present?
Present on the next stage.
Where? Chief Justice. Where is that? No, although Mr. H.S. Mishra, the counsel entered appearance for opposite party number 2, non-appearance. In the interest of justice, please also mention on first minute. Entry order continue. The registry will inform the advocate to remain present on the registry. The registry is informed. The order dated 27/3/2024 passed by this court has already been informed to Mr. H.S. Mishra, advocate. Advocate. However, none appears for opposite party number 2. None appears. However, none appears. Even for the petitioner, none appears. Interim orders in the present case, interim order dated 4/8/2017 is continued. Until date. The petitioner is not. It appears the petitioner is not interested to prosecute the present matter. Hence, the petition is disposed for non-prosecution. 14.
And for the petition of to file counter copy not served.
And none appears for petitioner from the second comment. Yes. Yes. Yes.
Mediation report is going to 106.
100?
Yes. 149 for the petitioner. OP to file counter affidavit, that is on list of 10. Copy not served.
Who is appealing for?
OP to inform dealers.
Nobody is appealing.
Matters. Nothing there for counter.
No, it's there. It's there.
Yes.
There. Nobody appears what to do. To whom you can request. Let counsel for the petitioner submits that although the opposite party number 2 has filed counter affidavit, but the copy of the same has not been supplied to him. Let the counsel for the opposite party number 2 supply the copy of the counter affidavit on the counsel for the petitioner. Lease the matter. Lease the matter. Yes.
Interim order continue.
Interim order continue. Yes.
118.
118. I was asking for the time for 118.
Yes.
Maybe granted me lots of.
You will be reading the agreement.
Lots.
You will be reading the agreement.
I present the case. I'm ready, lots. I was informed that they wanted time, newly appointed.
First time,
okay. Have to consider
1 week days. Interim order to continue.
Interim order.
Mr. Vishal, then counsel for the state seeks adjournment. Lease in account. Okay. Interim order to continue.
122.
Yes.
This is an unfortunate case. A daughter has filed a case against the mother. A sister has filed a case against the brothers and sister, nephew and niece. It's all in the family, my lord. An FIR was lodged. Prior to the lodging of the FIR, there are 2 civil cases pending where relief of declaring a sale deed to be void is there.
You are the mother.
And for the mother, sister and brother, nephew and niece. Everybody in the family who have been implicated.
And the opposite party number 2.
Party number 2 is another sister who has lost this FIR against us.
Against the mother,
brother, sister, nephew and niece.
What does she want?
Police investigated the case. Police filed final form stating that allegation cannot be substantiated. There is no case made out. Then protest petition was filed. On the basis of the statement of the complainant, cognizance will be taken. You also just imagine the allegation, whatever is the allegation is in the FIR. FIR was investigated by a competent professional body and found that no allegation cannot be substantiated. Somebody comes and makes a statement. Based on that statement, we will be all subjected to rigmarole trial manner. Just imagine matter. Merely because somebody comes.
He has examined how many witnesses?
She has examined 2 witnesses, but if
these 2 witnesses were examined by the police under 161.
Yes. If your office sees the
initial statement of the complainant, my lord. It is in the 32, page 32. 32, yes. My lord, does it reveal a case, my lord? So due respect. Let us see what are. On 27/11/2017, the occurrence took place at Damdarpur, Balasar on the residence of elder sister Vijayalakshmi and Tanuja Panda called me over phone to attend function Masinga Bazaar. I reached on 22nd and my mother took me house to Tanuja Panda on the next day. Tanuja Panda is sister, my lord. My mother told to go to house of elder sister. When I reached the house of my elder sister, told me to sign on some paper, but when I do not sign, they assaulted me. And accused number 4 called 2 persons who came and sat by me and abused me in obscene language. These 2 persons have not been accused. Who abused, they have not been accused because I have been made an accused. I want to log the FIR that police did not receive the FIR. They threatened me over phone, so I filed this case at court. How many properties are involved? But if you also see you are also directed for conciliation. Conciliation took place. Conciliation failed because of the unreasonable demand of OP number 2. It has been indicated in the conciliation order itself, and in the conciliation order reveals regarding pendency of the two civil cases, which is in the genesis of this case, madam. She is seeking a declaration that the same thing to be void. It will be decided by the competent court. Based on that, can you start a criminal proceeding, madam? And that is really like cognizable of the What do you want?
Page 23. See, I'll tell you one thing. You sort out your civil problem there by filing suit or whatever. What kind of criminal prosecution have you initiated? But there is competent body, according to Mr. Sharma, has investigated.
And the police has submitted the investigation final form, and he has stated in that form that it is true case under section 341, 294, 347, 354, 406, 418, 423, 427, 506, 3434 IPC, and there is no evidence. But it is
allegation has to be substantiated by evidence, madam. Allegation has to be substantiated by evidence.
You please spare your mother at least.
My lord, they have
only for property you will prosecute your mother.
They called the opposite party number 2 to their house and confined her and assaulted her and forced her to.
Okay, the suits are pending.
The allegation cannot be admitted in the trial. Pending.
What are the conditions? By the way, what are the conditions you impose for the settlement? What are the conditions? What are the conditions you impose for demanded? What is the demand?
That information.
Come to page 5 of mediation report.
That information not there.
Come to page 5 of mediation report. Mediator writes it. Both the parties are willing for amicable settlement. But OP imposes certain conditions which are not accepted by the petitioners. And the proposal given by the opposite party towards the land dispute and also present dispute, the petitioners have admitted same on the condition imposed by the opposite party, but they straightly denied to compensate, pay any amount to the opposite party for full and final settlement of all the civil and criminal disputes. What is the demand, by the way? What is
when I was told she is asking 25 lakhs in addition to the property we shall get as the co-sharer, she is demanding 25 lakhs. The old mother, where she'll get 25 lakhs?
Not old mother. The other
sharer, they are not the absolute owner of the property. They have a limited share bearer. It's an ancestral property, so everybody has a share. I cannot go beyond my share and say that from other share I also pay. Mother has a limited share.
Where is the property?
Balaswara, sir.
Behind her back, they have sold.
Everything. Have you earned anything? It is your parents' property. You have not earned anything.
Legal hair property.
Maybe legal doesn't mean that you will prosecute everybody and send everybody to jail, your mother and all. What is the age of your mother? No, don't try to be unreasonable. When you fight it out, if you want. See, if you want to fight it, nobody can stop you if you want to fight it out to the civil case. You fight out a partition suit, whatever. But how can you prosecute your mother who is 76-year-old for the property which you have not earned? It is your father who has earned.
It appears from the complainant, and prima facie it is made out.
I am not, let it be made out by the quasi.
So, trial will be required.
If it is a malicious prosecution, arm twisting method, then the court can pass it. This is completely a malicious prosecution, arm twisting method employed by you to get the property partition in your favor. You have filed a civil suit, there are 2 suits pending, your right will be decided there. You can't use this criminal prosecution to, prosecute your mother or to get the property. After all, you are a daughter. Daughter is supposed to be more sensible than the sons. Sons doing it sometime.
But number 2, and they have sold some property.
Will you settle it or pass it? You simply tell me, answer it. I will pass it. 11th, you come and make a straight statement. Otherwise, I will pass it. I am not interested. You fight it out, your right and the civil suit. Civil suit, you fight it out. If you win now, you win, you don't win. What to do? But you can't prosecute your mother. If I can understand, if your property would have been taken by your mother, you have not done anything. Your parents have earned. No, I will not read. I will not go into any paper because this is a criminal case. You have only filed to arm twist your sister, brother, and mother for the property. Police has investigated, filed a final form. No case is made out. It is interstate dispute.
But police has stated it is a true case.
Lack of evidence. True case will be established through evidence only. Okay, 11. You make a statement. Otherwise, I will pass it. And if you have the complete proposal, you come with a slip and give it to me. I will put it to them. If it is reasonable, let us solve it. In the family dispute, after all. What is your age? You are also 45. You are married. Are you married?
Married.
What is your husband doing?
They are staying at outside Rajasthan.
Big shots. Where?
They are staying at Rajasthan, my lord.
No. Address you have given Royal Enclave, Sri Vihar, Bhubaneswar.
That's the address in the complaint petition, madam. And statement also she made on the basis of.
No, I'll cross it. 11. You come with the proposal or otherwise I'll cross it. Let it be 12. I'm making very clear. Yes.
124.
Bhajanlal 7.
Yes.
Directly covered.
Bhajanlal
7.
Yes, there are 7 points. Yes.
As husband is Scindia versus Scindia, civil take supreme.
Covered.
Say that Rasla Badala, yeah,
Doesn't make out a case only to add.
Yes.
No, pleasure also.
Yes, madam.
My lord, this is a petition for the question of coordinates order, which is at question of coordinates order, which is at Annex 1, page 19.
Yes, Mr. Biswal, ready?
Let me go through the.
Madam, give one opportunity to them. Today only they have taken over. Huh? Next week?
Next.
Next week. Entry mode to continue. Yes.
126.
May I please? Both the petitioner and the opposite party, they have got married. Left with children. And proceeding is still pending because my father-in-law is initiated the proceeding. Entire thing I have.
Your father-in-law is the informant.
My friend is appearing on behalf of my wife because we are staying together. Everything is with me, my lord.
Where is the FIR?
My lord.
Charge sheet you have filed,
Copy
huh?
of the charge sheet along with the 164 statement I have annexed.
363, 376,
Yes.
and 506.
So 15, page 15 thousand 164.
What is the age of this girl?
से तो से कौन सी 28 कला 2015 से बाप कमे की करते ले अब वर्तमान लानी 29 वर्ष 29 series 2 kids out of the
From the charge sheet, show me what is the age?
charge sheet रे पहला
Have you filed anything to show that you are 29? Because the charge sheet was filed in 2016.
2016 2015 you also come to page 15. She has narrated the age 20 years before while her statement has been recorded under section 164. Page 15.
Yes.
What was it?
19 years. My age is 19. 19 years in the year 2015.
ମୁଁ ସନ୍ତୋଷ କୌରକୁ ଭଲ ପାଏ ଏବଂ ମୁଁ ଗତ
Yes, Mr. Vishal, what do you say? They are settling. The father is a hurdle for them. What do you say? Where are they? Where are they? Let me see the girl.
Oh, because my lord, this matter has been urgent to last.
Bring this girl. Let us understand. Let us ask her.
Can I pray? They were residing at Fulham.
When do you want to tell me? Tomorrow?
Tomorrow, yes, madam.
Tomorrow?
Tomorrow.
You bring them. Bring the girl at least.
Madam.
Both of them, let them come.
So he will appear through the bushi.
And make it the day after tomorrow.
Day after tomorrow.
Through IO of the case. Okay? Mr. Das, Land Counsel for the petitioner submits that the petitioner and the opposite party number 2 of the victim has already married and blessed with the child.
Two children.
Blessed with 2 children.
After that, birth certificate also.
2 children. Therefore, both of them jointly pray before this court for watching up the entire criminal prosecution initiated at the instance of the father of opposite party number 2 against the present petitioner. Mr. Das, Land Counsel for the petitioner further submits that the father of the opposite party number 2, who was the informant in the present, is not agreeing with the alliance. Alliance between the petitioner and opposite party number 2. But the fact remains that the victim and the accused have already married and settled in their life. He has already drawn my attention to the statement recorded by the police under section 164 CRPC. Statement of the victim, recorded under 164. In the statement, she has very categorically stated that she is 19 years of age and she has been in a relationship with the petitioner, and she had gone with her on her own volition. However, she has also stated that her parents are not agreeable to the alliance. Regarding head to the aforementioned, I am of the considered view that the victim, opposite party number 2, shall appear before the court through Vishi in the presence of the IO of the present case. The petitioner to be present in the court.
Can I clarify, Lordship? Because it is matter relating to 2015. IO court to IIC Banigocha PS.
List on make it on 8 because it is old matter. He has to communicate, na IO. He will have to communicate. IIC. So 8 because he has to communicate. Yes.
Can I clarify, Lordship? Entry order is there.
Entry order to continue.
Difficulty is that your Lordship directed to release this matter so and so that entry orders are continued. Lower court issued NBW because
where he has got that bill provision, giving that entry order has been vacated. To that extent, I filed the IA.
And you want to continue or aim to quasi to? Yes.
127.
Problem.
The petitioners have prayed for passing of the criminal proceeding. The OP number 2, my lord, in the year.
One minute.
On the last occasion, fresh notice was supposed to be issued. It was issued and it has been sufficient.
Sir, just see opposite party number 2 service.
Divorce has been granted to the right, my lord, at our behest.
He has taken the money.
And married elsewhere also now.
You get it verified from the IO?
Not sure. Regarding the status of the case.
No, not status of the case. What he says is passing of the FIR proceeding. Okay, not sure.
But as, my lord, I have also,
And yes,
paragraph 13, I have given to whom she has been married.
he says what he says is the lady, the complaint.
Not sure.
She is already married, she is separated and married someone else. So notice was issued, she will never come. Obviously, she is settled with someone else. Why she is not bothered? This case is going on.
Notice was issued in his new, her in the new matrimonial known as well as current.
Just verified from IO. Not sure what is the position, whether she is married or not. We will cross it.
Not sure. And judgment also I have annexed, my lord. The divorce proceeding.
You see, these are the 498A and all.
My lord.
He is not interested. Why should do it?
Not sure.
And when can you do it? Friday?
I not sure. Next week. Next week Monday. So.
11th, huh? Only you will verify.
My lord.
Service is complete, everything is done.
My lord.
Entry want to continue 11th.
Oh, bless me.
Please remind me on that day, please.
My lord.
Yes.
I will make a mention before your lord. Great, my lord.
128.
Parents-in-laws are there also, petitioners before your lord.
We will cross it.
Right.
That was lordship. In this case, my lord, the petitioner filed this case for crossing of the criminal proceeding, my lord. Notice was issued to the opposite party number 2.
See, service position level.
Lordship, I am appearing on behalf of the opposite party number 2.
Yes, he is appearing. Yes. Yes.
Register.
Any other debt, Lordship, we are concerned with her money, which has been cheated by the petitioners, Lordship.
How much?
My lord, total amount 21 lakhs. 21 lakhs.
Are you going to pay?
Yes, my lord.
Are you going to pay?
Already paid before the Lord trial court, my lord. After direct.
Already paid.
Lordship, in fact, the amount has been deposited before the learned court below.
Yes,
I
Lord.
earn my money along with the bank interest, Lordship, and the legal expenses, my lord. Because I have incurred a lots of expenses in this litigation, Lordship.
Recovery proceeding I have to clear out of this criminal case. Your litigation expenses, your everything, I will collect it for you.
Lordship, I may complaint the matter be posted to
Either you oppose it or you don't oppose it. That's the simple thing. You can't ask for litigation expenses and all.
No, it was my submission before Lordship. I know, Lordship, let the matter be fixed.
Let us see what state says. It is 420, 406 and 34.
Yes.
How many case, this is the individual simple cheater one case or a cheated money?
Lordship,
One case, your lordship.
no, actually, your lordship, what I've gone through, though I will be very honest regarding it. Lordship, there are two people involved, I guess. But, one is Mr. One name is this one Samir Mohammed.
Samir Mohammed. 16.
Samir Mohammed
16.
has also been arraigned as a person of interest in this case, my lord. Lordship, I will take instruction.
Take instruction because his name is not there in the petition.
It's not exactly clear.
Shubhasri Mahapatra and this is Arvind Shekhar Vishwal.
What is clear from the FIR is that she misrepresented herself before this complainant and took away the money and told those informant that she is the mutual fund expert or belonging to so and so bank, and on that pretext, she broke the FD that the complainant had made. That was broken by the FD, and she took away the money and invested, according to the story. But later on, the complainant came to know that she is not the mutual fund expert that she was. She possessed herself to be. She was not that. Rather, in order to fulfill her monthly target, she had misrepresented herself as that. But subsequently, she has deposited those aspects, those factual aspects are not clear as it is. I have to take
in this case,
but
the allegation whether the petitioner persuade the
See, you have deposited one mutual fund. What he says is, he has no problem. He is interested in his money. Let that money be released to him.
Yes, sir.
And what he says is, I had to bear legal expenses and all.
Yes, sir.
Why don't you? I'll send it to mediation. Why don't you settle it and pay something?
My lord, if this case has been filed after discussion between the parties and
Then pay something and finish it. Why should you make? I'm sending it to mediation.
Yes, sir.
It's not.
Yes, sir.
I'm sending it to mediation. The money which is lying deposit, that in any case you are going to get. And over that, whatever expenses, whatever interest you have lost, you persuade him and he may pay you something and finish it up.
That will solve this matter.
Okay.
Suffice, sir.
Phone to entered appearance on behalf of the opposite, Mr. Corida, appears on behalf of opposite party number 2. He submits that he has, he's only interested in his money which has been cheated by, allegedly cheated by the petitioner. The letter counsel for the petitioner submits that the entire disputed amount has already been deposited before the court below, and this can be released in favor of the opposite party number 2, and the criminal proceedings may be dropped. The petitioner, the opposite party number 2, has other claims as well. In view of the aforementioned, I am for the consent review. The parties will be relegated to the High Court mediation, sir. High Court mediation, sir, for exploring the possibility of settlement. The coordinator will be directed to fix a date and when can you go? You go on 6th. Both of you appear before mediation center.
6th November.
Mediation center. Appear before mediation center.
6th November.
Well,
14th.
Why?
A small child with the petitioner. 2 years child.
Petitioner may not go, her husband must be there.
Husband, my lord, she also bank manager because he cannot also.
You can then make it on 9th you go. 9th is the Saturday.
9th. Yes, lord.
The
second Saturday.
And opposite party number 2 shall appear before the coordinator of mediation center at on 9th. 9th at 2:30. 2:30 PM. And explore the possibility of a settlement. Release the matter on 14th.
Yes, lord.
9th probably second Saturday, let's see.
Saturday. Saturday. So mediation center staff member will be there.
Then 8th. 8th at 4:30. 4:30 evening. Okay. Release the matter on 14th. Deep